Hello everyone, welcome to the first class for Industrial Relations and Labor Law for EPFO. In this class, we shall discuss Industrial Relations and Labor Welfare theories. So, today's class will have three topics. First is the theories of industrial relations. Second will be the theories of labor welfare. And then the concepts of labor welfare. Okay. Once this is done, we shall move on to the substance part of labor law. Let us begin. So, what are industrial relations? Industrial relations refer to the relations between the management and the workforce in any industrial unit. This was very self-explanatory that it is the relations between the employer and the employee ultimately in an industrial setup. So, in any industry, there are top level managers, beneath whom there are middle level managers, and then the ground level workforce. So, industrial relations does not talk about relations between the management, but between the management and the workforce. All right. So, for example, there is a CEO, then they have managers under them, then the production manager will have foremen for fabrication, assembly, or any other aspect. The foreman will be the supervisor for the workforce. So, the relations between the manager, foreman, and the workforce is what will count as industrial relations. Between the CEO and the managers, this will be corporate governance. Corporate governance is outside the scope of the EPFO exam. Okay. So, in this class, we shall be dealing with basically what is industrial relations and how do we ensure the welfare of the workers. This is the core concern of the entire concept of industrial relations. Okay. So there are multiple theories or perspectives of industrial relations. They can be alternately called either theories or perspectives. So if the question comes on either of these topics, you have to consider the theories that we will be discussing in this part of the class. Okay. There are multiple theories, perspectives which exist to explain industrial relations. Why do we have industrial relations? What can be done to improve industrial relations? Should the state play a role in industrial relations? What is the objective of industrial relations? All of these are explained by different perspectives. It is important because which approach is adopted by the policy makers will decide the course that the law will take. So sometimes the policy maker might have a harsh view, a strict view of industrial relations, and they will have more state interventions. Otherwise, they might have a very lenient view and they can opt for very loose industrial relations law. Each perspective prescribes certain actions, as we will see for the future of industrial relations. All right. So we will be discussing 6 perspectives on industrial relations: the unitary approach, the pluralistic approach, the Marxist approach, the systems approach, the Gandhian approach, and V.V. Giri's approach. Okay. There are many other perspectives also, such as the sociological approach, industrial sociology approach, or the psychology approach. However, these are too technical. So I am just naming them so that you, if you want to read further, you might go through them, but these 6 should be enough. Alright. So let us begin with the first perspective of industrial relations, that is the unitary approach. The unitary approach says that there is only one source of authority, that is the management. The management owns and controls the dynamics of decision making, and therefore it is in charge of negotiation and bargaining. So this is an approach which says organization is one collective whole. Management is the center of it. It controls all organs equally. Okay, management is the center of the entire organization, and ultimately there is only one organization. The government should not be involved. The government involvement and tribunals are not required. The management should resolve all disputes with employees and workforce through negotiation itself. Okay, this says that the organization is self-sufficient to resolve its disputes. There should be no government, there should be no third party intervention. We will see over the course of the next few classes how industrial relations law have provided for labor commissioners, labor courts, as well as arbitration procedures to resolve disputes between the labor class and the capitalist class. However, this approach says that the organization is enough and you should not be needing for more managerial, you should not be needing more government intervention. The unitary approach says everyone's common good is advanced by cooperation, and workplace conflict is seen as a result of poor management. Strikes are considered destructive. Okay, this says that if there is workplace conflict, that means organization is failing. You don't need government restriction, because let organizations which are poorly managed fail. Let only the successful organizations which are well managed, they will succeed. So why have any government regulation when this is only a question of efficiency? This approach calls for harmony between workers and employers. This is the unitary approach. Alright. Now we move on to the pluralistic approach. The pluralistic approach is the opposite of the unitary approach. This approach says that the organization is composed of individuals who form distinct groups with their own set of aims, objectives, leadership styles, values, etc. Okay. So while the organizational approach said that there is only one leadership in an organization, which is the management, the pluralistic approach says there are multiple groups with their own interests, connections, desires, objectives, etc. within an organization. So it says that both workers and management will strive to wield economic and political power by bargaining for more wages. The workers will bargain for more wages. The management will bargain for less wages for the workers. The workers will bargain for less managerial supervision. The management will bargain for more supervision. And therefore, conflict between management and employee is rational and inevitable. Okay, this says that conflict between management and workforce is mandatory. It is going to happen anyway. It can't be stopped. Thus, trade unions are a valid way of representing employee interests. Please remember, in the unitary approach we had studied that strikes were considered destructive. They were considered so bad that you should not have them at all. Whereas in this case, trade unions and their actions are valid for representing employee interests. This approach says that concessions and compromises between management and employees lead to organizational growth. It is ultimately when both of these forces, the workforce and the employees, when both of them work towards each other, that they lead to upwards growth and mobility. They allow state to intervene to reach a compromise. Unlike the unitary approach that we had discussed, unitary approach said state should not be involved. Pluralistic approach says state can be involved to help the organization reach a compromise through the state's neutral adjudicators. They can help the organization reach solution. Okay. So this is the pluralistic approach. This says that the workers and management both are constantly struggling to wield more economic and political power, and therefore conflict will continue. Conflict is natural, conflict is good because it leads to growth. Now we come to the third perspective, the Marxist perspective or the radical perspective. Okay. The Marxists see industrial relations as a byproduct of the capitalist system, which incentivizes people only to seek profit. So many of you might know Karl Marx was a philosopher who laid the roots of communism as an economic theory, economic and political theory, which said that there are two classes of people, the bourgeoisie, which are industrialists, capitalists, etc. They control the means of production. Means of production are controlled by the bourgeoisie, and then there is the proletariat, which is the working class, who work for the bourgeoisie, who are exploited by the bourgeoisie. So this is the Marxist view that industrial relations are a byproduct of the capitalist system and they incentivize people to only seek profit. Marxists see conflict between workers and management as inevitable. Pluralistic view also saw conflict as inevitable. However, they view it as a power struggle between those who control means of production and those who offer labor. So unlike the pluralistic approach, which said that both of these are struggling to wield more power, this is to control more power altogether, that either power will belong to the bourgeoisie or they will belong to the workers. Marxists view trade unions as a weapon in the hands of labor to bring revolutionary change. Strikes are inherently political tool for Marxists. They believe that strikes are one way to reach a revolution. Marxists view pluralists as a part of the capitalist system. They say that pluralists are not opposing the system as a whole. They are only seeking employee interests within an organization. State intervention is seen as a way to maintain the interests of the management. Okay, state intervention is seen as a way to maintain the interests of the management, because ultimately Marxists say that state will help the rich, the industrialists, who will then use their managerial powers to exploit the workers, and the state then receives taxes from the rich So they will continue to help the rich, not the poor, because the workers are poor. So the Marxists say that the state intervention is also bad because they will only help the poor. These are the three traditional approaches. Okay. Which three have we discussed? We have discussed the unitary approach, the pluralist approach, and the Marxist approach. All of these are the three traditional approaches or perspectives to industrial relations. This is a comparison chart between all of these theories. In the unitary approach, the objective is harmony between all parts of the organization, whereas in the pluralist approach, the objective is representation of different sectional interests, be it employees, be it employers. All of them should have a say. And in the Marxist approach, the objective is conflict between bourgeoisie capitalist and the proletariat workforce. This is what they seek to address. Okay. Conflict is undesirable in the unitary approach. However, in the pluralist as well as in the Marxist, conflict is inevitable. Conflict is undesirable in the unitary approach because they see the entire system as one. So it is basically, for them, it is like thinking, what if the human body's hands say one thing and the brain says one thing? Then the human body will not work. In the same way, an organization is like a body and it should work together. Whereas the pluralists and the Marxists, for different reasons, they say that conflict will happen. Okay. The focus of the unitary approach is only on organizational performance. The pluralist approach calls for employee protection, and the Marxist approach is focused on the larger system of opposing capitalism as a whole. In the unitary approach, management is legitimate authority. The pluralist approach says authority should be distributed between different sections because all of them have different interests. And Marxists say that management is against the workers. Their interests are irreconcilable and opposed to each other. Trade unions are undesirable in the unitary approach because they cause strikes which can be destructive for business, whereas trade unions are a legitimate way of representing employees in the pluralist approach. And in the Marxist approach, trade unions are important to oppose the exploitation of the capitalist class. Only through united action can the workers oppose Marxism, can oppose capitalism. In fact, the Communist Manifesto begins with the word workers of different classes unite. So that is what they call for, and trade unions are the best way to unite workers. State intervention is unnecessary according to unitary approach and undesirable according to Marxists, but for very different reasons. The unitary approach says state intervention will hamper the organization, whereas the capitalists say state intervention will not benefit the workers. On the other hand, the pluralist approach says state intervention is important to ensure compromise is reached between the management and the working class. The solutions proposed in the unitary approach is that management should take care. Poor management is what causes conflict, so management should be compassionate. The pluralist approach says there should be a compromise between management and unions. both of them have to come to an understanding with each other, and ultimately the Marxists say that revolution should overthrow capitalism as a whole. Strikes are only one tool, but ultimately through violent revolution such as that in Soviet Union or in the Chinese state, communist China, there was a violent revolution. So that is what is necessary according to Marxism. Alright. Now we move on to the systems approach by Dunlop. Those of you who have studied sociology would have known this systems approach. Dunlop is regarded as the father of industrial relations because of the systems approach. He suggested that a social system is responsible for framing the individual's actions, that man is a product of their society, and what is our society shapes our mindset. The society shapes our mindset. There are three elements of the systems approach: the input, the process, and the output. The group cohesiveness is shaped by common ideology. We will discuss all of these input, process, and output separately in the next slide. Group cohesiveness is shaped by common ideology framed by societal factors. Industrial relations system comprises of actors, context, and ideology which binds them together. This is the final ideology of capitalism and which makes the capitalist system according to Dunlop. Okay. So the systems approach has actors, which means individuals or parties involved in the process of developing sound industrial relations, basically workers and management. Individuals. So if you have a kind individual as your manager, you will have better relations. If you have unkind people or argumentative workers, you will have rough industrial relations. Then we come to the context. The context refers to the setup in which the actors perform their tasks. This includes industry, markets, technologies, and the labor union's power. Okay, for example, if it is a high demand market, let us say for silk sarees, then workers will have more rights if they are skilled. Then we come to or let us say semiconductors. The semiconductor workforce is very highly skilled and the demand is very high. So the workers have a lot of rights. They are one of the highest paid. Semiconductor engineers are very highly paid in lakhs of rupees. Then we come to technologies. Technologies basically mean what kind of technologies are required to produce the materials. For example, if there is easier method of automation, then the workers will have less rights. If surveillance through CCTV is possible, then workers have less autonomy. If there is handloom work or handicrafts, then workers will have more autonomy to work. The last is power in the labor unions. If there are, let us say, if there are 10 labor unions, each with 10% of the workforce, then everyone has less bargaining power. Whereas if there is only one labor union with 100% of the workforce, or let's say 90% of the workforce, then that's a very powerful labor union. It can negotiate effectively. Then we come to ideology. The similarity of ideas, mentality, belief shared by actors helps to blend the system. Okay, let us say everyone works for national unity. The workers also believe they are working for national unity, and the management also believes they are working for national unity. Sorry for that. We were at ideology, that if the workers and the management both have a shared belief, then this will help bring harmony in industrial relations. So this is the function, the industrial relations function that Dunlop gave, that industrial relations are a function of all of these 5 that we have discussed. They are represented in the equation. R is equal to function of A, which is actors, M, which is industry markets, T, which is technologies, P, which is labor unions power, and I, which is ideology. So R is equal to function of F of A, M, T, P, I. Okay, this is the systems approach by Dunlop. Now we come to the Gandhian approach. Gandhiji stood for the following principles in all aspects of life, be it these were non-violence, truth, and non-possession or aparigraha. Alright, applied to industrial relations, he propagated the idea of trusteeship, that capitalists are trustees of enterprises. They hold the society, they hold the business in trust to the rest of society. They should take only as much as they need, and they should give up the rest for the benefit of all. The principle of Sarvodaya comes from this trusteeship model. Okay. Gandhiji advocated for non-violent resolution of one's disputes. He himself led the Ahmedabad Mill Satyagraha with Anusuya Sarabhai, through fast unto death. He did not normally recommend strikes or worker conflict. He opted for non-cooperation instead. However, he allowed strikes if and only if the cause was just and reasonable. Strikes should only happen if the capitalist fails to resolve their demands, and all workers should unanimously go on strike. There should be no compromise with the management later on, otherwise the strike will fail according to him. So unity in action was very important according to Gandhiji. This is the trusteeship model of the Gandhian approach, that capitalists should work for the benefit of everyone. Now we come to V.V. Giri's approach. The late President of India, Shri V.V. Giri, was a veteran trade unionist. He was a major labor movement leader. He preferred collective bargaining over the state-led adjudication of labor disputes. He said that trade unions should have lots of power to bargain with the management. He promoted bipartite dispute resolution measures in all workplaces prior to any escalation to third-party adjudication. So he basically said that before running to the state, to the government for resolution of disputes, one should come to the management first and bargain collectively for your rights. This can result in better outcomes according to V.V. Giri. Okay. These are the 6 approaches that we had for the theories of industrial relations. Now we come to the topic of labor welfare. What is labor welfare? Labor welfare refers to the efforts by employers to improve conditions of their workforce. It is an important dimension of industrial relations. It means adoption of measures to promote physical, social, psychological and general well-being of the working people. Safe working conditions, good environment for work such as cleanliness, painted walls, smelling nice, etc. Humble, cordial management. All of these are very important for labor welfare. Okay. So there are different ways of labor welfare. First is the statutory labor welfare, which is enforceable by law, such as maternity benefits. They are a law, you cannot violate them. You will have to face penalty otherwise. The other is voluntary. The employer decides on his own. For example, we have the concept of period leaves or menstrual leaves or mental health leaves also being promoted by many companies nowadays. So these are voluntary measures by the employers. Then there are extramural labor welfare measures which are outside the factory premises. For example, vacations to employees or educational facilities to employees. Then there are intramural labor welfare which is within the factory premises, such as restroom or canteen or dispensary, hospital, etc. So all of these are labor welfare measures, different kinds of labor welfare measures. Now we come to theories of labor welfare. Okay. Sorry, concepts of labor welfare we'll do first. After this we'll do theories of labor welfare. So these discuss why do people engage in labor welfare. Okay. Why should labor welfare happen? We'll be discussing these 6 concepts: commodity concept, machinery concept, charity concept, natural resource concept, citizenship concept and partnership concept. Let us begin. First is the commodity concept. These treat labor as a commodity. Okay. Wages were higher when the supply of labor is scarce in relation to demand for labor were low when supply was substantially in excess. So if there are many workers available, many workers, low pay, less workers, high pay. We look at examples of this such as farmers or agricultural laborers are paid less, whereas technical engineers, software developers are paid very highly. This gave rise to the idea that labor affected by law of supply and demand was like a commodity, because this was first observed through evidence. So then this led to the idea that labor is like a commodity, the price of which is determined by supply and demand for the commodity. All right. This is the commodity concept. Next we come to the machinery concept. The machinery concept said that commodity conception overlooked the fact that employer brought and sold not the actual labor but the products of the labor produced. He determined the value of labor by value of the goods and profit. So it's not as if I am buying one laborer. It's only that I am buying 1 hour of the laborer, and that depends on how productive is that 1 hour. Let's say A can produce 10 boxes per hour, B can produce 12 boxes per hour. Then B is more efficient. The employers thus started to regard their employees largely as machines capable of certain amount of output. Just as we try to purchase machinery and plant with lowest direct outlay, so we can hire labor as cheaply as possible, and just as we try to keep a plant operating economically, we can use and discard human labor according to the machinery concept also. So this is the basic concept that the machinery concept says. You only need to maintain labor welfare till you need the labor. After that, you can discard them when they are not of use. Okay. So the first one tried to treat laborers as a commodity. The second one tried to treat laborers as a machine, that they will work for production and nothing more is required from the employer. The third concept is the charity concept. According to this, it is the duty of those who were in fortunate positions to assist those who are in need. Basically, it says that the rich should give to the poor as charity. Charity was given for salvation of the donor or out of human sentiments with pity towards the distressed. Thus, labor welfare was mainly based on human and religious motive, and social workers were conceived as kind-hearted people who devoted their efforts to care protection of the needy. So in this concept, labor welfare is a charity. Alright. In the first one, the commodity concept, labor welfare was not necessary. In the second one, labor welfare was necessary only to maintain the labor. Once their utility was dropping, then you can discard the labor according to the second concept, machinery concept. According to the charity concept, it is a noble cause to help laborers, that is all, because they are poor. Then we come to the natural resource concept. The natural resource concept conceives labor as natural resources which the state should protect, just like the state protects its rivers, forests, etc. State should also protect its labor. This has been very important way of thinking for many policy economists. Out of this conception came child labor laws, restriction on hours of women workers, workmen compensation, etc. Because the state thought that you need to protect the labor resources of the nation. Then we come to the democratic concept or the citizen concept. In this concept, the workers are considered as citizens of the industry in which they are employed, and thus they are entitled to have a right to have a voice in determining the rules and regulations in which they work. All right, they are considered as participants in the industry, in the citizen concept or the democratic concept. Thus, labor has a right to be consulted in regard to terms and conditions in which they are supposed to work, because they are supposed to be citizens of the industry. Okay, please note, the democratic concept does not say that laborers are citizens of a state, that is why they deserve rights. The democratic concept says that laborers are citizens of the industry, so they deserve democratic participation in the industry. The result of this realization was industrial democracy, with shop committee, industrial council, employee representation plans, and so on. Okay, we'll also see how workmen committees, works committees, safety committees, canteen committees, all of these were recommended by the Second Commission on Labor, the First Commission on Labor, because of this. Now we come to the partnership concept. The partnership concept says that partnership relationships imply mutual responsibilities as well as sharing of fruits of joint endeavors. The earliest efforts were fostering stock ownership plans. Recently, profit sharing has come into prominence. Basically, if the organization succeeds, workers should get a bonus or a share in profits. Alright. Some argue that partnership concept is fallacious or false, as there can be no mutuality of interest between owner who is seeking large profits and workers who desire high wages. So some people, we saw the pluralistic view says that owners and workers have different interests. The Marxists say they have opposite interests, whereas the unitary approach says owners and the workers have the same goal ultimately. So the partnership concept says that you are partners in the organization and you should work together for the success of the organization. Okay. Now we come to the theories of labor. There are 6 theories of labor. What we discussed earlier were the concepts of labor. These are very interrelated, please note, but there are slight differences. The theories of labor provide for the assumptions. They say that labor welfare is already happening. But why is it happening? Is the question that the theories of labor welfare try to answer. Unlike the concepts of labor welfare, which said, should labor welfare happen at all? The theories only provide justifications or reasons. Okay. While the concepts provided for questions on whether or not they should happen, the theories of labor welfare provide for reasons on whether they should happen. There are 6 theories that we will discuss. The police theory, the religion theory, the philanthropic theory, the trusteeship theory, the placating theory, and the functional theory. Alright, we will discuss these 6 theories of labor welfare. and then we'll move to the previous year questions. First, we come to the police theory. This theory assumes that man is selfish and self-centered and always tries to achieve own ends even at the cost of welfare of others. According to this theory, the factory and other industrial workplaces provide many opportunities for owners to exploit workers in an unfair manner. This is done by making labor work for very long hours, paying unfair wages, not keeping the workplace hygienic, ignoring safety health provisions, etc. Therefore, the welfare state has to prevent this exploitation, and it assumes the role of a policeman and makes it mandatory for managers to provide for welfare facilities and also punishes non-compliers. So this police theory says that welfare state must be a watchman and ensure labor welfare happens, otherwise it will not happen, because the main assumption is that people are selfish and self-centered. Alright. Then we come to the second theory, which is the religion theory. The religion theory consists of two aspects, investment and atonement. The investment aspect states that fruits of today's deeds will be reaped tomorrow. आप जैसी करनी वैसी भरनी, you might have heard. Therefore, any action is treated as an investment, and inspired by this aspect, some employers plan and organize canteens and creches. Basically, you can be a good employer, and this will help you in the long term or in the next life. The atonement aspect of religion theory says that current disabilities of an individual are outcomes of sins committed by him or her previously. Therefore, he should pledge to do good deeds now so as to atone or compensate for sins. Alright? That if you do good karma, you will be better later. So the religion theory says that people provide for labor welfare because they want to do good karma. Otherwise, they would not have provided for labor welfare. This is what the religion theory says. Now we move on to the philanthropic theory. Philanthropy refers to the affection for mankind. It is basically the idea that rich people provide for charity. This theory of labor welfare refers to provision of good working conditions, creches, canteen, drinking water facilities to remove the disabilities of the workers. This says that human misery should be resolved by charitable actions. Employers having concern for their workers may undertake such labor welfare measures for the benefit of the workers. So, here the employer is engaging in labor welfare because of concern for the workers, affection for mankind. In the religion theory, they were doing it for good karma later on, but in the philanthropic theory, they are doing it for good well-being of employees. Okay, this is the main difference. We move on to the fourth one, the trusteeship theory. This theory we will see is Gandhian in origin. The trusteeship theory is also called paternalistic theory of labor welfare. According to this theory, employer of the or the industrialist holds the total industrial estate, profits and properties in trust. Workers are also not able to take care of themselves for reason of lack of education, low wages, etc. The employer should provide well-being of the workers out of funds that are in their control, because they are the trustees who have been entrusted with responsibility of worker well-being. This is called paternalistic theory of labor welfare because it says that the employer is like a parent of the worker, of the employee, and they should continue to provide good labor welfare so that the labor can become better. Otherwise, the labor, because of lack of education or low wages, will not be able to take care of themselves. This is the trusteeship theory. Then we come to the placating theory. The placating theory is based on the assumption that appeasement pays when workers are organized and militant. Basically, this is a Marxist theory. It says that workers are going to revolt against the state and the industrialist. The worker shall revolt against industrialist. Therefore, industrialist should keep workers happy. In order to prevent any rebellion. The workers' demand for higher wages and better working conditions cannot be left unattended. Therefore, some welfare measures need to be taken so as to bring peace. This is what the Marxists say, that labor welfare is only appeasement. Appeasement is to please someone, to make them happier and to prevent any discomfort to that person. Okay. Labor welfare is appeasement according to the placating theory. Placating itself means appeasement or to pacify. Then we come to the functional theory. The functional theory is also called the efficiency theory of labor welfare. It states that welfare facilities are provided so as to make workers more efficient. We also discussed something similar in the machinery concept, that you help the laborers till they are of utility. The workers will efficiently work if they are treated kindly, if they are provided with clean and safe working conditions, good canteens, etc. Welfare work is a method of securing, preserving and increasing the efficiency of labor, because this way the workers will not leave, will work hard. Therefore, this is one good way according to the functional theory of labor welfare, that the assumption is labor welfare is provided to increase the efficiency of workers. Alright, these were the 6 theories of labor welfare. So in today's class, till now we have covered theories of industrial relations, theories of labor welfare, and concepts of labor welfare. Okay, there were 6 theories, 6 concepts, and 6 theories of labor welfare also. Please remember there are more theories of industrial relations, but because of the technical nature of the other 6, I have not covered them so far. Now let's come to the previous year questions. First, which one of the following perspectives of industrial relations is based on the assumption that both parties strive and have the opportunity to exercise economic as well as political power? Economic power is wages and benefits, and political power is control. So, which of the following perspectives says that is based on the assumption that both parties strive to exercise economic and political power? A. Pluralistic perspective, B. Unitary perspective, C. Radical perspective, and D. Trusteeship perspective. Let us see. The trusteeship perspective said that the employers hold in trust. There is nothing about striving or struggling to exercise power. In this, all power is entrusted. So, this can't be the answer. The radical perspective said this is a power struggle. Radical perspective is the Marxist perspective. Okay. Power struggle, which is political in nature. Marxists don't talk about economic power. For them, economic power is only a way for political power. And they mean political in the large sense, the capitalism sense, not the organizational sense. The unitary perspective does not have both parties. It only has one party which has power, the management. So all of these can't be. The pluralist perspective says there are multiple stakeholders competing for power. Both economic and political. Economic is less or more wages, and political is supervision or control. Alright, so the answer is pluralistic perspective. Okay, we move to the next PYQ. Which one of the following explains the citizen concept of labor? A. Labor is largely regarded by employers as operating organizations in industry. B. Labor is affected by law of demand and supply. C. Labor has a right to be consulted in regard to the terms and conditions under which they are supposed to work. And D. Labor is a cog in the machine. Let's see. The first one, labor is regarded by employers as operating organizations in industry, is the partnership approach, the partnership concept. Labor is affected by the law of demand and supply, is the commodity concept. Labor has a right to be consulted in regard to terms and conditions under which they are supposed to work, is the citizen concept or the democratic concept. Labor is a cog in the machine, is the machinery concept. Okay. The answer is C. Labor has a right to be consulted in regard to terms and conditions in which they are supposed to work. Next question. The assumption that man is selfish and self-centered and always tries to achieve his own ends even at the cost of others explains which theory of labor welfare? A. Placating theory, B. Police theory, C. Religious theory, and D. Philanthropic theory. Let's see. Placating theory said that all labor welfare is to prevent labor unrest. Police theory said man is selfish and self-centered, so the welfare state must act as a watchman. The religious theory said that good karma is an investment which leads to atonement. You will reap good rewards in the next life or later on because of labor welfare. And the philanthropic theory said that people do labor welfare because they care about human well-being. So the answer is B. Police theory. Okay. That is all for today. Thank you. Hello everyone. Welcome to the second class of Industrial Relations and Labor Law for EPFO. In this class, we shall discuss the evolution of labor law. Okay, let us begin. So the point which will be starting from is the 19th century. The origins of labor law exist in the system of British colonialism, because British colonialism introduced the Industrial Revolution to India in the 19th century while exploiting labor conditions in the subcontinent. So industrial relations started with the Industrial Revolution. That is why we look at the 19th century, the 18th and the 19th century as a beginning. The industrialists formed the first organizations in British India to collectively protect capitalist interest. Okay. At first there were the landholder societies, and then there were the plantations and the factory owners clubs. The factory owners clubs, all with Europeans normally. Especially the plantations and the factory owners clubs had European capitalists in them. They lobbied with the government. They did lobbying with the government to protect capitalist interests, and initially there was no organization to protect labor interests. The advent of trade unionism happened in the 19th century in Europe as well as in Britain. Why? Because the Industrial Revolution had started in the 18th century in Britain and Europe. So in the 1780s, the Industrial Revolution had started in UK and Europe, but only in the 1800s did it start in India. So that is why by the time it started in India, there were already concept of trade unions in Britain and Europe. Also, early socialism theories such as those by Bakunin, B.A. Kunin. He was one of the early socialist philosophers. They gave boost to the Indian labor movement also. By the 1860s, Karl Marx had published the Communist Manifesto. And socialism and communism had risen significantly. So the Indian labor movement also started mobilizing. We will discuss three parts. First is the labor movement prior to World War I, pre-World War I, post-World War I, and post-independence. Okay. The pre-World War I labor movement had four distinct phases. First was the early labor organizations from 1870 to 1880. Then was the Factories Act of 1881, which provided the first labor law in India to regulate working conditions of factory workers. Then came the Factories Amendment Act of 1891, and later on in the 1890s to 1910, there were strikes which were organized by nationalist leaders in pursuance of the freedom struggle. So these were the labor movements that we will discuss. First we come to the early labor organizations in 1870 to 1880. In 1870, Sasipada Banerjee started the Working Men's Club in Kolkata. This was the first ever labor organization. This was not a trade union. Okay, we will discuss trade union in a separate class, but this was only a labor organization. It was a club and nothing more. Sasipada Banerjee also started a newspaper later on called the Bharat Shramjeevi. Shram means labor. So Shramjeevi is a laborer who lives by his labor. So Bharat Shramjeevi was a newspaper started by Sasipada Banerjee. Later on, SS Bengali campaigned in the Bombay Legislative Council about the rights of the labor class. SS Bengali had also led the 1875 labor agitation. Okay. In 1880, N.M. Lokhande, Narayan Meghaji Lokhande, he is one of the pioneers of labor movement in India, started the newspaper called Deen Bandhu with a few friends. The newspaper Deen Bandhu is one of the most famous newspapers and journals you might have read if you are also preparing for the UPSC exam, the civil services exam, that this was the first labor newspaper altogether which highlighted problem of the working conditions. Later on in 1890, Lokhande set up the Bombay Mill Hands Association. This was also not a trade union but an association of workers. Okay. N.M. Lokhande made several contributions to the labor movement, especially in the early years. Firstly, that they should get a weekly holiday on Sunday. Second, in the afternoon, workers should be entitled to half-hour recess for lunch. Thirdly, The mill should start working from 6:30 in the morning and close by sunset. You might think 6:30 is too early in the morning, but if you read records, mills could start from 3:30 a.m. also at times. People had to give up their sleep, their time with families, etc., only to work from before the sunrise to after sunset. Labor conditions were that bad. Salaries of workers should be given by 15th of every month. Nowadays, employees get angry even if salaries are not paid by the 5th. Some even have the 1st as their deadline of every month. But without any law, there were massive delays, such as 1 month delays, 2 month delays, and for poor laborers, that is unbearable. So these were some concessions that Lokhande was able to get from the mill owners. In 1881, the first Factories Act was passed. The context for this, the background for this was that in 1875, a labor agitation was organized by S.S. Bengali. He also, in 1878, he campaigned in the Bombay Legislative Council for this. This led to the appointment of a labor commission in 1875. The British capitalists were worried that growing rivalry from Indian textile industry and Indian plantation owners would negatively affect their interest. Therefore, they called for Factories Act to regulate labor conditions in factories. Overtly, openly, this was a welfare legislation, but secretly it was a protectionist measure to protect British capitalist class, because the Indian capitalists were also competing for cheap labor. Okay. The provisions of the Factories Act 1881 therefore they were adopted during the reign of Lord Ripon. From 1880 to 1884 he was the viceroy. They prohibited labor for children under 7 years of age. Imagine, even 6-year-olds used to be employed before this. They limited factory work for children under 12 years of age, that they could only work for a limited number of hours. There was a mandatory fencing requirement for dangerous, hazardous machinery which could cause threat to life. They provided rest during the day to workers, and there was no provision for trade unions. Trade unions was not allowed at the time of the Factories Act 1881. Okay. This did not apply to British plantation owners. It applied to Indian plantation owners. Therefore, this was an unfair playground to protect the British capitalist interest. So British capitalists could hire children under 6 years of age. They could make children below 12 years of age work for very long hours also without any restriction. After the campaigning of N.M. Lokhande, the Factory Amendment Act 1891 was passed. This increased the age limit of child prohibition to 9 years. Earlier it was 7 years. Now this was made 9 years. It also fixed daily 9 hours work for child labor between 9 to 14 years. Earlier it was 7 to 12 years. Now this was made 9 to 14 years. 11 hours work for female laborers labor. Daily half an hour break for tiffin to all workers. 1 day compulsory rest in a week. This was also NM Lokhande's demand for Sunday off. That was accepted in the Factory Amendment Act 1891. This also did not apply to British plantation owners. They could continue with whatever they wanted to do. Alright. Then we come to the nationalist strikes. Many nationalist leaders, in furtherance of the Indian freedom movement, involved labor class, working class, because they realized they are powerful and many in numbers. Lokmanya Tilak, Bal Gangadhar Tilak, organized a major Eastern Railway strike in 1899. He had also campaigned for it in Maharashtra, written in his newspaper Keshari about the strike. Later on, Tilak went to jail for 6 years because of his strike. Also for other reasons, but from 1908 to 1914, Tilak went to prison. Also, during the Swadeshi movement, which was from 1905 to 1907, multiple political strikes were organized across India, wherever, especially in Bengal, Bombay, Punjab, and South India. Multiple leaders organized strikes. V.O. Chidambaram Pillai and Subramanya Siva led major industrial strikes in southern India, in different parts of the Madras province. Alright. So these were the pre-World War I changes. Labor movement. Everything changed with the First World War. Why did they change? Firstly, there were excessive shortages and inflation during the First World War. The workers had to face harsh living conditions. Secondly, labor movement in India had gained impetus due to leaders like Mahatma Gandhi, Tilak, Annie Besant, Lala Lajpat Rai, etc. There were now multiple people who were mobilizing their leaders, mobilizing the labor class. Then the Russian Revolution happened, which led to establishment of a worker-led socialist state. The USSR was established. Prior to this, only emperors, rich people were owners of states, were rulers. Suddenly, workers became the rulers, and this was the first time that the world had seen an ideological state, a worker state. So this changed the philosophy that many people lived with. This gave a lot of confidence to workers that they could overthrow oppressive capitalist system. All right. Lastly, the ILO, the International Labour Organization, was set up in 1919. India was a founding member of the ILO. So all of this happened from the period of 1914 to 1919. We had the World War I. We had various leaders rising up, such especially Gandhiji. In this time, Gandhiji returned to India and he started many of his Satyagraha programs. The Russian Revolution in 1917 and the ILO in 1919. All of this gave impetus to the Indian labor movement very significantly. What all happened? The first registered trade union in India was established by B.P. Wadia, called the Madras Labour Union in 1918. Okay. Trade unions work for collective bargaining. Collective bargaining of the labor class with the management of the industries. There was also the general strike at the cotton mill in Ahmedabad in 1918, supported by Mahatma Gandhi, led by Anusuya Sarabhai and Shankar Lal Bankar. They later founded the Ahmedabad Textile Labour Association in 1920. So in 1918, a trade union was registered in India. This is the first ever trade union of India. In 1920, in Ahmedabad, this was a labor association was started. The All India Trade Union Congress, the oldest trade union federation in India, was set up in 1920. It was founded by Lala Lajpat Rai, Joseph Baptista, N.M. Joshi, Diwan Chaman Lal. These were founders of the Indian labor movement in the 20th century. Lajpat Rai was elected as the first president of the ITUC, the All India Trade Union Congress. Okay. This was also the effort by the Indian National Congress to bring labor into national movement by addressing their issues first. Okay. The government also recognized these changes. There was the non-cooperation movement, which happened up till 1922. After that, there were elections in which Congress won a lot of seats. So the government recognized that some things have to be done. They passed the Trade Union Act of 1926 and the Industrial Disputes Act of 1929. Both of these provided for collective bargaining powers. The Trade Union Act allowed for trade unions to be official now. So they greatly benefited because they were conferred, trade unions were conferred legal and corporate status for registered trade unions, and it granted them certain immunities in regard to trade disputes. So therefore, trade unions could not be sued in court for criminal intimidation if they provided a threat to strike. So they successfully negotiated this right that they could now strike without being prosecuted. The Trade Union Bill 1926 was opposed by many people. So it was also sought to be amended. The attempt to dilute trade disputes bill met with opposition, including Bhagat Singh's HSRA. Bhagat Singh had thrown a bomb in the assembly, the legislative assembly, for discussion of the trade disputes bill. So all of this was to oppose the trade disputes bill, which sought to dilute the provisions which allowed for such powers to the trade unions. Okay. So these were some changes which happened after World War I, wherein the government recognized, the British government recognized the power of the labor movement. Afterwards, after the Bhagat Singh conspiracy as well as the Meerut conspiracy, which was a communist conspiracy in 1929, the Royal Commission on Labour was set up. It is also called the Whitley Commission because its chairperson was John Henry Whitley. Okay. The commission submitted its report in 1931. The outcome of this report made way for series of labor legislations from 1932 to 1947, such as Payment of Wages Act 1936, Trade Disputes Amendment Act 1937, etc. In between, there were the round table conferences going on in Britain. So there was no step which was taken. Before this, there was also the civil disobedience movement going on. So no step was taken. From 1935 onwards, the British government started once again. After the Government of India Act was passed, Government of India Act 1935 was passed. After that, multiple acts were allowed. Okay. Please understand the historical contexts in which this was happening. I am just giving you a brief outline. In pursuance of the recommendation of the Royal Commission on Labour, the Office of Chief Labour Commissioner was established in 1945. It was charged with the duties of prevention and settlement of industrial disputes, enforcement of labour laws, and to promote welfare of workers in industrial establishments falling within the sphere of central government. Okay. There were multiple industrial establishments, some within the state governments, some with the central governments. States had autonomy as per the 1935 Government of India Act, and the center was largely under the Viceroy with a executive council. So the Royal Commission on Labour provided for various labour legislations as well as a office of a Chief Labour Commissioner who could work for settlement of industrial disputes and enforce labour standards and labour welfare. This went on until 1945. After that, in 1947, we gained independence. Now we come to the post-independence labour law. Alright. After independence, the labour movement became merged with the idea of a welfare democratic state. India was a welfare state after independence, no longer a colonial state, and we had a democratic form of government which cared for its citizens. Citizens, not subjects anymore. Therefore, the state started taking care of its people. In 1947, prior to independence, the INTAC was established, the Indian National Trade Union Congress. This was because the ITUC, the All India Trade Union Congress, ITUC, became involved with the Communist Party. And so therefore, the INTUC or the Indian National Trade Union Congress was established in 1947 in cooperation with the Indian National Congress. Even today, most parties have their own trade union wing because there is a lot of labor class who are also voters. So therefore, people engage in mobilizing the workforce. Also, the first labor minister of independent India was Babu Jagjeevan Ram. Babu Jagjeevan Ram was a legendary Congress leader. He was an untouchable. He led the All India Depressed Classes League, one of the Congress arms, Congress wing for untouchable people. He was the first labor minister. Later on, he also became the defense minister of India during the 1971 war. And he is one of the most celebrated Dalit politicians in the Congress. So Babu Jagjeevan Ram was the first labor minister. The first industrial policy of independent India was declared in 1948 by Shyama Prasad Mukherjee. The Industrial Policy Resolution of 1948 laid down what the new democratic state expected to bring from industry. Okay. The Industrial Policy Resolution of 1948 declared Indian economy as a mixed economy. It focused on small scale and cottage industries and gave them a lot of importance for the growth of India. That these would be the foundations on which India would grow. The government restricted foreign investment. We had recently come out of colonial rule, and as we all know, the East India Company, which led to British colonialism ultimately, came as a foreign investor initially. So there was a lot of distrust. In the foreign investors at the time. India wanted to become self-reliant back then. We wanted to become our own industrialized nation ultimately. Therefore, industries were divided into 4 categories. First was the exclusive monopoly of the central government, such as arms and ammunition production, etc. Arms and ammunition production of atomic energy, management of railways, all of these were the exclusive monopoly of the central government. The second category was new undertakings, undertaken only by the state. Coal industry, iron industry, steel manufacturing, aircraft manufacturing, shipbuilding, telegraphs, telephones. All of these were the exclusive responsibility of the state. For example, we launched the Mines and Mineral Development Regulation Act for exclusive coal mining, iron mining, for classification of minerals into major and minor minerals. All of these helped the Indian state take control over the major pillars of economy. Then we come to the third sector, which is the industries which are to be regulated by government, industries of basic importance but which have private participation, such as automobiles, food products. All of these had private participation, but they will be regulated by the government. and the last would be those which are open to private enterprise, individuals and cooperatives such as shops, vegetables, etc. So these were the 4 pillars of the industrial policy. Please understand, a very large presence of state meant large state employment. The state will be directly responsible for labor welfare ultimately. So this meant that the state was going to take the major burden of labor employment on itself. The independent Indian state also took up lot of new legislations such as the Factories Act 1948, the Standing Orders Act 1946, Minimum Wages Act 1948, Payment of Bonus Act, Maternity Benefits Act, Payment of Gratuity Act, etc. All of these were taken up after independence because the Indian state was taking up the major role in labor employment. Alright. Afterwards, in 1966, the first National Commission on Labour was set up under the chairman of Justice P.B. Gajendra Gatkar. He was the former Chief Justice of the Supreme Court of India. And so he led the first National Commission on Labour. The commission submitted its report on August 1969 after detailed examination of all aspects of labour problems, both in organised and unorganised sectors. Alright. So this was not limited to formal employment. This also included informal employment. The first National Commission on Labour recommended there should be a works committee, safety committee, canteen committee, etc. in any unit which has a recognized union for participation of workers. To promote participation of workers in management, all of these steps were supported because this is how workers could suggest measures for their own well-being. How will you know what the workers want if you don't speak to the workers, right? Therefore, you need different participatory committees for understanding worker issues. It also recommended growth of collective bargaining, recognition of unions, prohibition and regulation of strikes and lockouts. Prohibition is prohibition of alcohol. Okay, because if workers appear drunk, there can be many accidents in the workplace. And regulation of strikes and lockouts to promote harmony in industrial relations. Strikes are done by trade unions where they refuse to work, and lockouts are done by the employers where they refuse to let the workers enter the premises. We will discuss all of this in the coming classes when we discuss industrial disputes, but this is what the first National Commission on Labour recommended. Okay. This was in 1969 when the report was submitted. The second National Commission on Labour was set up in 1999 under the chairmanship of Ravindra Verma to report to PM Atal Bihari Vajpayee on the changed labor conditions. Because post 1991 reforms, there were LPG reforms, the liberalization, privatization, globalization, had happened in 1991 economic reforms, and after that there was more private involvement, much less government involvement. Therefore, there was a need to change the circumstances. The Second National Commission on Labour recommended that existing labour laws should be broadly grouped into 4 or 5 labour codes. Imagine, this was said in 1999 and the 4 labour codes were enacted ultimately in 2020, 20 years later. The commission said 4 or 5 labour codes on functional basis, basically on subject matter, by simplifying, amalgamating and rationalizing the provisions of the 44 central labour laws. There are 44 central labour laws and every state also has certain powers to regulate. So this was considered a major problem which the Second National Commission on Labour tried to address. The labour code classification would have also helped ultimately in allowing private sector to move smoothly. This is only something that was ultimately took place in 2020, and even now the codes have not been enacted. Okay. There are constitutional provisions for the welfare of labour. First, we come to part 3, fundamental rights. Part 3 of the Constitution provides for fundamental rights. Therein we have Article 16, which says equal employment opportunities in public employment. So there can be no discrimination in public employment on grounds only of race, religion, caste, sex, place of birth or descent. Okay. Please note that Article 16 also provides for one exception of residence, that while you cannot have any discrimination on grounds of residence, the Parliament can prescribe such conditions. So although Article 16 says that residence cannot be a ground for discrimination, it is only by the state government or local government who are restricted completely. The union government cannot discriminate, but the Parliament can make a law for such a discrimination. But regardless of this, there can be no discrimination on the grounds of religion, race, caste, sex, place of birth or descent. Okay. Then we have Article 19. Article 19(1)(c) includes the freedom to form unions as a part of freedom of association. So the freedom to form trade union is a fundamental right. There is no right to strike. We will discuss all of this when we discuss trade unions and industrial disputes. There is no right to strike, but there is a right to form union. You can always form a collective of people. That is your fundamental right to freedom of association. Then we have Article 23, which prohibits human trafficking and forced labor. Activities such as begar, which was unpaid labor, forced labor, they have now been prohibited under the right against exploitation. Similarly, Article 24 is also under the right against exploitation, which prohibits child labor. It says under 14 years of age, no child can be employed in hazardous industries, factories or mines. So this is a fundamental right of all citizens, that you cannot be engaged in such activities, hazardous activities. Now we come to part 4, which is directive principles of state policy. These are not enforceable in courts, but the Constitution states that they are fundamental for governance. These are not justiciable because every society needs to have resources to provide for socio-economic rights. Fundamental rights are political rights. Directive principles of state policy are socio-economic rights. That is why they are not enforceable, but they are important for the governance of India. So, the most important one is Article 39. Article 39 says both men and women should have equal means of livelihood. Basically, it guarantees women the right to work. Second, the ownership of material resources must be distributed in society. Please remember the general Marxist, socialist notion that it is the material resources and means of production which decide power in any society. There are 3 parts to the Constitution's DPSP: the Gandhian, the Liberal and the Socialists. So Article 39 is a socialist clause. Okay, it says ownership of material resources must be distributed in society. Economic system should not lead to concentration of wealth and means of production to the common detriment. Because if there is too much concentration of wealth or means of production, it can harm society ultimately. There is equal pay for equal work. Health and safety of workers should be upheld, and children should be allowed to develop without any exploitation. They should not be forced into labor in any way. Article 24 says no forced labor in mines, hazardous industries and factories for 14 years of age. Article 39 says they should also generally not be forced into any form of labor. Other DPSPs say Article 41, which says there should be right to work and public assistance for those people who need it, who need public assistance or who cannot earn their employment immediately. Then is Article 42, which provides for just and humane conditions of work and maternity relief. So this is not just basic conditions, but more than that. Then we have Article 43, which talks for living wage for workers. There is something called minimum survival wage, then something called fair wage, which is non-exploitative. Then we have living wage, which is not just enough to survive but to live a healthy life. as a whole. Then we have participation of workers in management of industries in Article 43A. Okay. Article 43A was added by the 42nd Amendment by Miss Indira Gandhi. She was a very hard socialist in ideology. Participation of workers in management was added by the 42nd Amendment to Article 43A. Okay. So these are the 5 DPSPs we discussed. Article 39 as well as Article 41, 42, 43, 43A. There are powers in the 7th schedule which provide for different levels of legislature and government to enact laws and to execute policies on different subjects. First, we have list 1 or the union list. In it, entry number 55 is regulation of labor and safety in mines and oil fields. These are specified in MMDR Act, which mines are to be taken care of. Second is entry number 61, which is industrial disputes concerning union employees. In this case, this is capital U, union government employees. Union government. And third is union agencies and institutions for vocational training. So basically for strategic mines, oil fields as well as union employees and institutions, the union list has a power. State list has exclusive powers normally for employees of public hospitals, for mines and mineral development, except for the strategic mines. Except for strategic mines, they have the powers for mines and mineral development and to lay down policies. And entry number 33, for cinema, public theatre and dramatic performances, all employees in the entertainment industry come under the state list. Okay. Now we come to the 7th schedule subjects in concurrent list. Entry number 22 provides for trade unions, industrial and labor disputes. Entry number 23 provides for social security, insurance, employment and unemployment. And entry number 24 provides for welfare of labor, conditions of work, provident fund, employee liability, workman compensation, invalidity, old age pension and maternity benefits. Basically, most labor statutes are from list 3 concurrent list. Both states and union have the power to legislate on the union subjects, on the concurrent subjects, and all labor codes essentially fall under the concurrent list. Only strategic sector mines and oil fields and union establishments fall under union, and hospital staff, cinema staff, fall under states, and other mines also fall under state. Okay. The International Labour Organization is one of the most important organizations for regulation and development of labor standards across the world. It was set up in 1919 by the Treaty of Versailles. It was the same treaty that Germany opposed later on under Nazis, and ILO became a part of League of Nations. India was a founding member of the ILO. Presently, ILO is an independent organ attached to the UN since 1946. Earlier it was part of the League of Nations. Now it is no longer a part of the UN. It is an independent organ attached to the UN. It releases the World of Work report, and it also provides for multiple conventions, including 8 core conventions. There are 100 plus conventions of the ILO which lay down standards of work. India held the position of chairperson of governing body of the ILO from October 2020 to June 2021. Labour Secretary Shri Apurva Chandra held the post of chairperson of the governing body of ILO. Okay. In 1944, the ILO gave its Philadelphia Declaration, which had 4 major objectives. Firstly, Philadelphia is a place in USA. Firstly, labor is not a commodity. If you remember, we discussed the commodity approach that labor depends upon demand and supply. So the first principle laid down is that labor is not a commodity. Second is freedom of expression and of association are essential to sustained progress. Basically, there should be right to form union, and employees should not be curtailed from fundamental rights. Third, poverty anywhere constitutes a danger to prosperity everywhere. Basically, if there is poverty in one land and richness in another land, the rich will dominate the poor of the other land, and this will cause people to grow poor in this land and exploitation to continue in this land. Okay, so both places will have more inequality as a consequence. So the idea is that poverty anywhere constitutes a danger to prosperity everywhere. Lastly, the war against want, which is greed, requires to be carried on with unrelenting vigor within each nation and by continuous and concerted international effort in which representatives of workers and employers enjoying equal status with those of governments join with them in free discussion and democratic decision with a view to promotion of common welfare. This lays down a formula of representatives of workers, employers at equal status with government. These three form the tripartite committee in the ILO. This is why this declaration is very important, because it says that government employees and employers are together responsible for coming up with decisions, and this declaration lays down the structure of the ILO. So the ILO has tripartite dealing. There are 3 organs of ILO: the International Labour Conference, which is like the General Assembly; The UN General Assembly, you might know, all countries have one seat. It meets every year in the month of June. Then there is a governing body, which is like the Executive Council or the Secretariat, the Security Council in the UNSC. The governing body is the version. It meets 3 times in a year in the months of March, June and November. And the last is International Labour Office, which is a permanent secretariat, which ensures that the organization's job is done all round year. The Labour Conference, International Labour Conference, has a tripartite committee, okay, which involves trade unions, governments and industrialists. Okay, please remember the fourth objective of the Philadelphia Declaration said workers, governments and employers will have equal status and democratic decision making. So this is the way they ensure democratic decision making, by having a tripartite committee in the main decision making body. Alright, the governing body and the International Labour Office also have a tripartite system, but it is the International Labour Conference which has the main role in taking the decisions ultimately. There are 8 core conventions of the ILO which lay down standards, minimum standards of labor welfare. First is the Forced Labor Convention, which prohibits forced labor. Even in India, forced labor is banned under Article 23 as a fundamental right. Similarly, the Abolition of Forced Labor Convention, Equal Remuneration Convention, which provides for equal pay for equal work for all genders to prevent discrimination against women. Normally, women are paid less than men even for the same amount of work, and that is heavily discriminatory. Next is the Discrimination Employment Occupation Convention, which prohibits discrimination on grounds of race, religion, etc. for employment. Then we have the Minimum Age Convention, which prohibits child labor. Similarly, we have the Worst Forms of Child Labor Convention, which India signed a few years ago. Then we have the Freedom of Association and Protection of Right to Organize Convention, and the Right to Organize and Collective Bargaining Convention. These argue for the right to strike and right to collective bargaining. India has not ratified the convention number 87 and 98, basically the 7th and 8th convention we have not ratified. Please also remember the convention numbers: Convention 29, 105, 100, 111, 138, 182, 87 and 98. These are the 8 core conventions. India does not recognize right to strike as a right of any person. It is only an opportunity given through statute as per Indian law. So that's why India has not ratified the 7th and 8th core convention of the ILO. Now we shall discuss some previous year questions. Okay. First, Works Committee, Safety Committee and Canteen Management Committee are examples of A. Workers' participation in management. B. workers' education schemes, C. workers' cooperatives, or D. workers' suggestion schemes. Now this question has two confusing options, A and D. Workers' participation in management and workers' suggestion schemes both could be correct, because all of these committees don't have executive powers, they normally have advisory powers. That is why UPSC deleted this question from its answer key. Both A and D could have been correct. So there were no marks awarded for this question. It was only asked. Next, the provision of workers' participation in management of industries is provided under which article? A. Article 39A of the Constitution. B. Article 43A of the Constitution. C. Article 42 of the Constitution. Or D. Article 43B of the Constitution. Article 39A is for free legal aid to the people. Article 43A is for participation of workers in management. Article 42 is for just and humane conditions of work. And Article 43B is right to form cooperatives. So we see the answer is B, Article 43A. Next question. Which of the following is not part of the aims and purposes of the ILO as per the Philadelphia Declaration? A. Labor is not a commodity. B. Freedom of expression and of association are essential to sustained progress. C. Poverty anywhere constitutes a danger to prosperity everywhere. D. The war against want requires to be carried on with unrelenting vigor within each nation and is solely the responsibility of the government. You might see these are verbatim lifted from the Philadelphia Declaration, all four of them, except beyond this point, the war against want requires to be carried on with unrelenting vigor within each nation. Now it says, and is solely the responsibility of the government, whereas the declaration said through concerted international effort from workers, employers and government equally. So this part is wrong and therefore answer D, because it does not provide for the correct aim and purpose in the Philadelphia Declaration. Alright, thank you. This was it. Hello everyone, welcome to the third class for Industrial Relations and Labour Law for EPFO. In this class, we shall discuss trade unions. Let us begin. Firstly, what are trade unions? Trade unions are those organizations of employees or workers who work for the maintenance and enhancement of their economic status. So firstly, they work to ensure that their standards don't go down, and secondly, they try to improve their working conditions as well as wages, economic status. They insist in various ways for rise in money wages as well as improvement in working conditions and benefits. They provide opportunities for collective action to workers, and they also fulfill the need for socialization, as workers are also human beings with social needs. So basically, trade unions are groups or associations of people who are engaged in industrial employment. Industrial employment. Okay. These groups collectively bargain for better living conditions, working conditions, as well as wages. And as you might have heard, that there is strength in unity. Trade unions also work on the same principle, that there is strength in unity, and therefore collective bargaining will yield better results. Let us first discuss the history of trade unions. So trade unions, as we saw in the last class, developed in India in the 19th to 20th century, but they emerged in Britain in the 18th century after the advent of the Industrial Revolution. It came to India later because Industrial Revolution came to India in the 19th-20th century, whereas it started in Britain in 18th century. Laborers would engage in collective bargaining of employee contracts with employers. They would also collect fees called union dues to fund legal battles that workers faced, such as unfair termination. So by pooling resources, they could fight the rich capitalist class, which have access to big lawyers, which have access to important resources as well as connections. So through collective bargaining as well as pooling of resources in union dues, they were able to match up to the rich classes altogether. This is how trade unions came up. They later on came up in India also by the end of the 19th century. We saw that N.M. Lokhande formed the Bombay Mill Hands Association in 1890. B.P. Wadia formed the first official trade union by the name of Madras Labour Union in 1918. The Bombay Mill Hands Association was only a workers' association. The Madras Labour Union was the first official trade union in India. By this time, Gandhiji and Anusuya Sarabhai had also started the Ahmedabad Textile Mills Association by 1920. In the same year, the All India Trade Union Congress, the ITUC, was formed in 1920 only. Lala Lajpat Rai was its first elected president. This was a federation of trade unions. So they could have trade unions from textile, from manufacturing, etc. From multiple industries, trade unions would exist, and all of them would collectively come under the ITUC. We saw in the history of trade unions class last class, that ITUC later went to the communists. So by independence, there was a new trade union called INTUC, the Indian National Trade Union Congress, which became the Congress arm. Even today, all political parties have their own trade unions. The Bharatiya Mazdoor Sangh is also a famous trade union federation, which belongs to the BJP. So all of them have their own systems of trade unions because there are too many workers who form a political class. So everyone wants their political support and vote. Okay. There are different types of trade unions. The first type is a craft union. A craft union is one where people are workers of the same craft. For example, let's say goldsmith or sari make weavers. or beady makers. But workers of the same craft form a union together. They come together to safeguard their interest. They are called horizontal unions. Why? Because you could be working for different employers, but all of you come together to form one union. And then we have the second category, which is the industrial union. The industrial union works for one employer or factory. So just the way craft union was the same kind of employees, the industrial union is multiple employees of the same industry coming together, of the same employer coming together. So let us say factory foreman of factory A will work with the workers of salesmen of factory A, and factory foreman of factory B will work with the salesmen of and workers of factory B in an industrial union. Whereas in a craft union, the foreman would have been one union altogether. Then we have the general union, which is the third category. The general union are workers from all labor classes in general for policy lobbying. So they form a union across craft, across industry, sometimes even across region. They generally want better labor standard altogether. So a general union might consist of all of these simultaneously. Okay, so these are the three types of union. What are the differences? Firstly, that craft union is called a craft union is a horizontal union because it has workers of the same class and craft working together. An industrial union is called a vertical union because it has various levels and crafts of employees within the same industry or factory being one employee. And a general union is a union of all laborer class altogether so that they can portray strength in numbers for larger political lobbying purposes. Let's say such as minimum wages, right? That general minimum wages should go up for all laborers. If that is a demand, then that is a common demand for all labor class. So there are general unions also. Mostly these are trade federations, trade union federations. Okay. So these are the three types of trade unions. Robert Hoxie is a famous sociologist. He came up with a classification of trade unions on functional basis, that what is a trade union going to do and what is it dependent upon the objective and function of trade union. He came up with a classification of 5 types. First is a business union, second is a revolutionary union, third is a predatory union, fourth is a friendly or uplift union, and fifth is a dependent union. Let us discuss what these are briefly. So the first is a business union. A business union is also called a bread and butter union because they are directly concerned with economic interest only. So they are trade conscious rather than class conscious. They accept the economic system and aim at bringing improvement in wages and working conditions of their members. Collective bargaining is the usual method followed by unions with heavy reliance on strike as a weapon. So a business union is one which seeks better wages, better working conditions. They are not concerned with ideology such as communism, capitalism, etc. They are only concerned with better wages, better working conditions. They are pragmatic and they don't challenge the system as a whole. They are only concerned with their own well-being. The second category is the revolutionary union. The revolutionary union is basically the exact opposite of a business union. The revolutionary union is opposed to the capitalist industry system as a whole, and they seek to replace it with the socialistic system through radical means such as strikes, boycotts, and ghirao. They are class conscious and view the entire industrial system as one of oppression and seek to overthrow the oppressive bourgeoisie class. So, as we saw in the Marxist approach in the first class, that there are sections which view the entire capitalist system as oppressive, and that can only be solved via takeover of means of production. So the revolutionary unions try to use coercion. They also threaten employers at times. They sit on radical strikes. They declare bandh or general strike across regions at times. So these are the revolutionary unions. They are a lot more popular, or were a lot more popular, in the Eastern European region as well as in the Soviet states. The third category is predatory unions. Predatory unions do not subscribe to any ideology in particular. They are only characterized by their ruthless pursuit of immediate ends. They are formed only for political power in industrial setup. For example, let's say there are 50 people, 50 employees in an industrial setup, and over some minor issue or some one-time issue, one of them calls for power, that let's negotiate with the administration, with the employer about our rights, and they all collectivize, or let's say 35-40 of them collectivize out of 50. Now this person will speak to the administration and he might engage in bribery, he might threaten violence, he might actually be a good person and he can take up collective bargaining. But these are not long-term unions with any ideological purpose. They only want immediate grievances to be redressed and nothing more. So these are called predatory unions, that they will seek any issue to survive. Okay. Now we move on to the friendly or uplift unions. These unions mainly aim at improving the intellectual, moral, and social life of their members. These unions are not craft conscious. They rather focus on the interest of workers. They are idealistic in nature. Since they are law abiding, they believe in the institution of collective bargaining and also setting up cooperative enterprises, mutual insurance, profit sharing, and the like. So these are welfare associations basically. Which might be open to all employees, or there must be some criteria. However, unlike the revolutionary unions, revolutionary unions don't believe in collective bargaining. They believe in strikes and lockouts and strikes and other political tools such as gherao and picketing. Whereas friendly unions believe in collective bargaining as well and setting up organizations for the benefit of everyone. Then we come to the last category, which is a dependent union. A dependent union relies upon the support of employers and other labor groups. They exist as long as their members need a union, sometimes only as a temporary measure. Let's say an employer sets up his own union to stop union activities elsewhere. Or let's say one political party wants to have a union inside a major industry, let's say sugar mills. Sugar mills have a lot of political lobbying. So let's say a political party wants a trade union in a sugar mill. So that union will be dependent upon the larger interest group. If the political party no longer exists or fails an election, then that union might also be dissolved suddenly, that they might not get the funding or the support that they need to continue their own operations. They don't have any agenda or existence of their own except for the need for someone else for them to exist. Okay, so these are the 5 types of unions that we discussed. The business union, which only care for the immediate welfare and economic interest of their workers, not immediate but the economic interest of their workers. Then come the revolutionary union, which care for overthrowing the entire capitalist system through strikes, gherao, etc., which don't believe in collective bargaining. Then we came to predatory unions, which only care for political power in the immediate surrounding. Then we come to friendly unions or uplift unions, which work for the people, which work for the employees regardless of their craft. And lastly is the dependent union, which works on someone else's agenda. Alright, these were the 5 by Robert Hoxie. Okay, let us now move on. Unions can also be classified on the basis of the arrangement or the agreement that they have with the employer. Okay, on this basis there can be a 6-fold classification: closed shop, union shop, preferential shop, maintenance shop, agency shop, and open shop. However, these arrangements are not recognized in India. They are more popular in the West, especially the USA, than in India. In India, it is possible, however, there is no legal sanction for such arrangements, and it's also not practiced very often. In India, there is no such culture of trade union arrangements with employers. Let us briefly discuss this because this is not something that happens in India. We just need to brush over this once. The first is the closed shop. In this arrangement, the management and union agree that the union would have the sole responsibility and authority for recruitment of workers. It is called a closed shop arrangement. The worker joins the union to become employee of the shop. Basically, there is one industry, one shop, and one union which has all the employee, and then there is the management. Everyone who wants to be a part of the establishment must join the union. The union is responsible for recruitment. It performs the function of HR. This basically ensures that the workers are constantly represented in the management. Then we have the union shop. In this case, the workers upon recruitment and possibly the passing of a fixed period must become member of the union. Okay, so here recruitment is done by the HR department or the management only. However, after joining, it is necessary to be part of a union. Okay, it's also possible that there are more than one union. Sometimes there are 2 to 3 unions, all of which bargain for the rights as well as recognition. Third is the preferential shop. Preferential shop arrangement is when the union member is given preference in filling a vacancy. Such an arrangement is called a preferential shop. So it's not necessary that the employer will only hire union workers, nor is it necessary, it is not necessary that every employee must join a union. However, if a union has presence across 4 to 5 industries, then membership of the union might be a better way to recruit people. So these are called preferential shop arrangements. Then we come to maintenance shop arrangement. Maintenance shop is when any new worker does not automatically become member of the union. However, they must continue to compulsorily be upon joining, they must continue to compulsorily be member of the union and help other workers. So this is basically union has permanent membership. It's not necessary to join, but if you join, then don't leave. That is called the maintenance shop. In the agency shop arrangement, agency shop arrangement, there is no obligation upon new workers to join a union. but they must pay a regular fee to the union instead of membership subscription. So, for example, if you don't want to be part of the campaigning or activities, mandatory camps of a union, sometimes it so happens that a union is not restricted to one employer, they are present across the entire industry, across entire sector. You don't want to be a part of the large scale politics of a union, so you just pay a regular fee to the union and then don't join their membership. That way also you are free from the regular hassles that they will otherwise be putting you through. The last is the open shop arrangement. In open shop arrangement, there is no obligation to join any union before or after employment. Sometimes organizations don't have any union at all. For example, Tesla as an organization does not have any union. So this is also possible that sometimes there is no relation of the employer with the union. There is no relation with any union. Such an arrangement is called open shop. Okay. In this case, unions have no power. No power. So these were the different kinds of arrangements based on the classification based on arrangement with different employers and unions. Okay. Next we come to the Trade Union Act. This is the main act which registers, recognizes and registers trade unions. Okay. The Trade Unions Act 1926 provides for registration of trade unions with view to render lawful organization of labor to enable collective bargaining. This is to facilitate unions in a lawful manner. It also confers registered trade unions with certain protection and privileges. There are immunities from law. We'll discuss that trade unions get once they are registered. All right. The purpose of this law was to give a legal sanction to trade unions. Therefore, trade unions here means any combination, whether temporary or permanent. Okay. So it could be that initially the combination was meant to end in some time. It is possible that sometimes you don't want or don't plan so much that your trade union will last for very long. However, the combination's functions are important. It should primarily be for the purpose of the functions of regulating the relations between workmen and employers, between workmen and workmen, between employers and employers, or for imposing restrictive conditions on the conduct of any trade or business. Okay. Therefore, for registration of trade union, you can have employer-employer, unions also, as well as business unions also. That will determine how you will conduct business. All of these are possible, but there are multiple other acts which are similar, and so everyone except for laborers prefer those acts, such as the Societies Act, Trust Act and the Registration Act. So other organizations, let's say FICCI, will not prefer to be registered as a trade union because it gives a negative connotation that it's a laborer organization. For a wealthy capitalist, they don't prefer such a link. So normally it is the relation between workmen and employers and workmen and workmen. These are the only two which normally get registered as trade unions. Although for any industrial purpose, you can have a trade union ideally. Membership of a trade union is available to any person above the age of 15 years. This is because the Factories Act provides 15 years as the age limit for adolescents. We will discuss over the few classes who is an adolescent is different in the Factories Act, is different in the Minimum Wages Act, etc. And this causes a lot of confusion. However, while any member can be 15 years or above, an office bearer, someone who will do the executive task of a trade union, has to be above 18 years of age. If they are not above 18 years of age, they are automatically disqualified. Okay? An office bearer shall also be disqualified if he has been convicted by a court in India of any offence involving moral turpitude and sentenced to imprisonment, unless period of 5 years has elapsed since release. Moral turpitude is corruption or outraging modesty of women, rape, theft, etc. All of these are offences of moral turpitude. So if you have been imprisoned, then after 5 years you can once again be the office bearer of a trade union, not before that. 5 years from release, not from your conviction date. Now remember, a trade union has to be registered. Without a registration, they don't have much value in the eyes of law. The entire purpose of the TU Act, the Trade Unions Act of 1926, was to give a formal structure to trade unions. This would allow some consistency in operations. This would also lead to accountability on someone, that at least someone has to bear responsibility and accountability for any action. So let's say if there is a strike, if there is any damage during a strike or picketing. Picketing is when you try to shout slogans or to close down someone else's shop because it's not selling the correct stuff, or basically hurling different kinds of words or negative discouraging words upon an industrial shop. So if a damage is done during all of this, then someone has to be held accountable. So for that, there has to be a formal process, a registration, so that you know who is to be held accountable. So for this, there is a minimum limit of 7 or more members of a trade union who should apply for the registration of the trade union. That these are like the promoters of a company, that you should have at least 7 members who are willing to give their name as the founding members of the trade union. So ultimately, if something happens, the police might just come up to them to ask कि भैया क्या हुआ. If someone has to be arrested, they might be arrested. They have to stake their own capital, their own freedom to ensure that the rights of the workers are ultimately met. There is a registrar of trade unions who shall be appointed by the appropriate government. Appropriate government means either center or state government depending upon the industry. We saw that there are multiple different industries which are regulated by the state or the center according to different lists. So for whichever list one might fall in will decide who will appoint the registrar of trade union across all, because labor is mostly a concurrent list subject. Across all legislations that we'll discuss, you will come across the term appropriate government. Appropriate government. Why is this? This is to ensure that both state and central government, whichever is applicable, is allowed to make laws. You can't question their authority or their power to make laws. So whichever is the appropriate government will appoint a registrar of trade unions. The registration application must have details of the members of the trade union as well as its registered office, so that if police or any inspector has to arrive at one place for accountability, they know where to come. The trade unions existing for more than 1 year must also submit their accounts. So they have to give an account of their expenditure, of their fees, expenses. All of these have to be noted down because these are formal organizations. Ultimately, you are no longer an informal union or association, you are a proper formal organization. So the registration application has to consist of all such details which can allow its traceability, which can allow people to understand what this organization is, how big is the trade union, what is its spending, how many members do they have, where is its registered office. All of these details have to be provided. Okay. There are benefits for registration also, that upon registration the trade union gets perpetual succession and a common seal. We saw in the classes on accountancy that companies have a perpetual succession and a common seal. Trade unions also get a similar stature, that a common seal means that actions are not of individuals but of the trade union itself. It's a separate legal entity. It becomes a separate legal entity in itself, and all other similar aspects such as the power to acquire and hold both movable and immovable property, the power to enter into contracts, the power to sue and to be sued. So basically, during a trade dispute, the trade union has the power to go to court as well as to enter into settlements with the employer. Okay. So these are some powers which are consistent with that of a company, that you get all the benefits of a separate legal entity. Now there are other benefits of being a registered trade union. First, that you get immunity to all members from criminal conspiracy relating to any aspect furthering the purpose of trade union. For example, if you are spreading the agenda of wage rise, there is no criminal conspiracy that you are committing. Under IPC, there is a specific provision for criminal conspiracy, section 120B of the IPC, which says that if two or more people conspire to cause a crime, so spreading the agenda of a wage rise or for a strike or for picketing, all of this cannot be sued for conspiracy, because this is one of the purposes of the trade union. So you can't be sued if you are a member of a trade union and doing all of this. So this is the criminal liability that you are exempt from as a member of a trade union, a registered trade union. The second benefit is immunity from any civil suit against any member for any act in relation to trade dispute. So for civil actions, you are also immune from any action relating to a trade dispute. We will discuss what a trade dispute is, but the moment something becomes a trade dispute, there is immunity from actions such as trespass, such as nuisance. All of these you will not be sued for, because suppose you are picketing a shop or a factory premises, then you are standing at the factory gate and you are telling other workers to not go inside, or you are telling customers that there is a problem with the shopkeeper who is not paying wages, and therefore you are conveying your own grievances. Now normally you can be sued for nuisance, you can be sued for trespass, that you are unauthorized and you are standing there. But if you are a member of a trade union, then you will not be sued for anything that is a trade dispute. Okay. So these are the benefits of registration, and that is why it's important to get your entity registered as a trade union. Now, all trade unions we discussed in the chapter on not-for-profit organizations, there is a general fund. Okay. So similarly, all trade unions also have a general fund. This general fund can be used only for the specified purposes. There are 9 purposes in this slide and in the next slide. Okay. And only for these purposes can the general fund be used. First is the payment of salaries, allowances and expenses to office bearers of the union, even travel expenses, etc. Whatever the union decides to reimburse to the office bearers, because the office bearers are spending their time and money. Sometimes they are workers just like other workers, sometimes they are political workers, they do nothing else except for this trade union politics. But if they are spending their time and energy for the purpose of the trade union, then definitely they deserve to be reimbursed for this purpose, and therefore the Trade Union Act allows that out of the general fund of the trade union you can pay them an amount. Okay. Second is payment of the expenses for administration of the trade union, including audit of accounts of general fund of the trade union. Audit is mandatory. Please remember that if you have to submit your accounts to the registrar of trade unions, this is not trade onion, this is trade union that I wanted. Then you definitely need audit. Otherwise also the rent of office, etc., all of these is possible that you have to bear, and you will have to bear expenses, and those expenses will be borne from the general fund. The prosecution or defense of any legal proceeding to which trade union or any member is a party, when such prosecution or defense is undertaken for purpose of securing or protecting any rights of the trade union as such, or any rights arising from relations of any member with his employer or the person whom the member employs. Okay, this means that employers can also be a part of a trade union and employees can also be a part of the trade union. Either of these. But if there is a legal dispute, then the general fund of the trade union can be used for this purpose of resolving this legal dispute. Fourth is conduct of trade disputes on behalf of trade union or any member thereof, because the members have joined the trade union for collective security, for collective bargaining. So even if one member is fired unlawfully, or let's say they are penalized for something that they did not do or something that was not warranted, then the trade union can collectively also fight. Call it a trade dispute and they can fight it. There is also immunity for everything that is related to a trade dispute. For compensation of members for loss arising out of trade dispute, if any member is injured or if any member is fired, even if they are fired for 3 months, they are workers in a factory, they have lost a lot of wages for 3 months. So the trade union can compensate those members for losses arising out of trade dispute. Next is for allowance to members or their dependents on account of death, old age, sickness, accident or unemployment of such members. Sometimes it happens that trade union members are fired for their activities. So the trade union has to take care of the consequences of the members. Ultimately, if they worked for the trade union, you have to work for your member. Next is the issue of or undertaking of liability under policies of assurance on the lives of members, under policies insuring members, etc. So basically, insurance policies the trade union can collectively buy for all its members. These are, we discussed, there are uplift unions, friendly or uplift unions, which only work for the benefit of its members. So this is something that is allowed for trade unions to do out of their general fund. As the provision of educational, social, religious benefits of members, including payment of expenses for funeral or religious ceremonies for deceased members or for the dependents of members, because trade unions are sometimes the most important social organization in the life of a worker. That workers don't have a very big social life outside of their employment, so the trade union normally takes care of their expenses in a very good manner. Last is upkeep of a periodical published mainly for the purpose of discussing questions affecting employers or workmen as such. Sometimes there is a journal, newspaper, etc., which a lot of trade unions might maintain to publish their agenda, to publish their life, or merely to allow their members to have a creative output. Anything could be the reason. But for these purposes, you can use the general fund. There are also some restrictions on the use of the general fund. Firstly, the general fund can only be used for the 9 purposes above mentioned and for no other purpose if it is found that for personal gain someone has used, then they will be liable to compensate as well as liable under section 425 for criminal misappropriation of property and for criminal breach of trust. Because if an office bearer is entrusted with property of the trade union and if they use it for their own purpose, then that is a criminal offense under the Indian Penal Code. Political activities fund or any fund for any political purpose has to be separately maintained. You cannot use general fund for this purpose. No member can be compelled to contribute to the fund for political purposes. So while contribution to the general fund can be made mandatory, you can have subscription fees. Subscription fees for general fund. You cannot have subscription fees for political activities fund. Okay. And lastly, the accounts have to be submitted for the general fund annually. The registrar of trade unions shall receive the accounts from all trade unions about the utilization of funds from their general fund in an audited report. Okay. Now, what is a trade dispute? If something is a trade dispute, then it allows immunity to the trade union as well as its members. So what is a trade dispute? The trade dispute means any dispute that means divergence on question of fact or question of law. This is what a dispute is. So there has to be a divergence on the question of fact or law between employers or workmen, or between workmen and workmen, or between employers and employers. So all of these three, let's say these workmen could also be very different workmen. One could be a foreman, factory foreman, the other could be an assembly line worker, or it could be between two assembly line workers who both say that they were not responsible for an industrial accident. All of these are possible. So a trade dispute is any dispute between employers and workmen, or workmen and workmen, or employers and employers. Okay, which is connected with employment, non-employment, terms of employment, or condition of labor. So if you refuse to give someone job after 3 months, even though you hired them for 1 year, that is a trade dispute. If you give a job to someone who is not a member of the union, let's say in a closed shop, if you give a job to someone, then that will also be a trade dispute. Although closed shop is not something common in India. Then terms of employment. Let's say you are supposed to pay them certain commission on sales, but you did not. That is a trade dispute. Or conditions of labor. Let's say you are supposed to give them 2 hours of break every day, one in the morning, one in the afternoon, but you only give them one break in the afternoon, not in the morning. That can also be a trade dispute. Okay, of any person. So it need not be any specific person. It can be the employment, non-employment, terms of employment or conditions of labor of any person. Let us say a worker is deceased. Worker is deceased and their son was promised a job. Son was promised a job. Now this son is not an employee as of now. Is not a workman, but he was promised a job. So therefore, the non-employment can be taken up between employers and workmen. That other workmen through the trade union can also raise this question and bring up the problem that you also have to hire them. The question of non-employment is valid for everyone. Workmen here means all persons employed in trade and industry, whether or not in the employment of the employer with whom the trade dispute arises. Let's say you have to hire across some other factories workers because you are absorbing them. So even then, it is possible that if you refuse to absorb some of them, that can be a trade dispute. So it has a very wide connotation, and therefore there is a lot of immunity from civil action the moment there is a trade union which is registered. All right. Now we come to the previous year questions. A union whose membership may cover workers employed in many industries, employment and crafts is known as A. Industrial Union, B. General Union, C. Craft Union, D. Region cum industry level union. We discussed if there are many industries, employment and craft, then it is a general union. Okay, the answer is B. General union. Next question. Which one of the following is an exception from the 5 functional types of unionism identified by Robert Hoxie? A. Business unionism, B. Predatory unionism, C. Revolutionary unionism, or D. Evolutionary unionism. We discussed all of these: business unionism, predatory unionism, revolutionary unionism. There is nothing called evolutionary unionism. So therefore, the answer is D. Evolutionary unionism. It is an exception to the 5 functional types because this is not discussed. Next question. Which one of the following is not a trade union security measure? Not a trade union security measure. A. Closed shop system, B. Agency shop system, C. Open shop system, or D. Union shop system. So in a closed shop system, you can only hire from the union. In an agency shop system, they must pay a regular fees to the union even if they don't join. In an open shop system, there is no obligation upon the new employees to join a union or to not join a union. They are completely free to decide what they want. In a union shop system, ultimately every new recruit has to join a union. So therefore, in an open shop system, there is no trade union security because there is no relation. So therefore, the answer is C, open shop system. What is the minimum number of members required for registration of a trade union? A, 2 members, B, 3 members, C, 7 members, or D, 10 members? We discussed. The answer is C, 7 members. Okay. Which of the following disputes is or are considered as trade disputes under the provisions of Trade Union Act 1926? Any dispute of any person connected with employment, non-employment, or conditions of labor. As we saw, the trade dispute can be something connected with employment, non-employment, terms of employment, and conditions of labor. Therefore, all of these are correct. 1, 2, and 3 are correct. The answer is C, 1, 2, and 3. This is it. In the next class, we shall discuss industrial disputes. Thank you. Hello everyone. Welcome to the 4th class of Industrial Relations and Labor Law for EPFO. In this class, we shall discuss the Industrial Disputes Act. This is the most important industrial legislation as of now, and until unless the 4 labor codes, you might have heard in the news that in 2020, 4 new labor codes were passed by the government. Until unless those labor codes become operational, the Industrial Disputes Act and the Trade Unions Act remain the most important labor laws in the entire country. We discussed the Trade Unions Act in the last class, and in this class, we shall discuss the Industrial Disputes Act and its provisions. Okay, let us begin. So the Industrial Disputes Act 1947 came into force on the 1st of April 1947 and extends to the whole of India and regulates Indian labor law so far as that concerns trade unions as well as individual workmen employed in any industry within the territory of India. The objective of the Industrial Disputes Act is to secure industrial peace and harmony by providing machinery and procedure for the investigation and settlement of industrial disputes by various measures such as conciliation, arbitration, adjudication, which are provided for under the statute. The law applies only to the organized sector. It is not for the unorganized sector. It is not for the unorganized sector. This law provides for various concepts such as strike, lockout, workman, employee, industry, etc. And we shall be looking at those definitions as well in this class. Besides the structures such as the conciliation officer, arbitration, labor courts that have been provided for under the Industrial Disputes Act. Why was the Industrial Disputes Act needed? Industrial dispute is a disagreement between employer and employee's representative, usually a trade union, over pay and other working conditions and can result in industrial actions. When an industrial dispute occurs, both parties try to pressurize each other. Sometimes the trade union might resort to strike, or the management might resort to lockout. Ultimately, it is the productivity of the economy that suffers, and it might also create a law and order situation sometimes. So the management as well as the workers both need to create harmony at the workplace. In fact, there is one major case of the Supreme Court called John Matthew versus State of Kerala, which specifically discusses the violence that occurs during a general strike between a factory workers and a factory owner, and when not can it amount to a criminal offense. So a lot of violence occurs at the time of industrial disputes at times, because workers are also agitated, the management is also angry that work is stopped, and they are also threatened that if the workers can do anything such as stone pelting, then they can also use firearms, guns. So there is a major need to curtail the industrial disputes that can happen. Okay. Therefore, the principal objectives of the Industrial Disputes Act are: firstly, promotion of measures for securing amity and good relations between employer and workmen. Amity is friendliness. So, promotion of measures for securing friendliness and good relations between employer and workmen. Second is investigation and settlement of industrial disputes. For this, there are various measures provided for in the Act, such as a court of inquiry or a labor commissioner, etc. Third is prevention of illegal strikes and lockouts. This is one of the most important provisions, that it gives conditions when strikes or lockouts can happen. So therefore, anything that is outside of this scope is an illegal strike or lockout. Fourth, relief to workmen and procedure in the matter of layoff, retrenchment and closure of an undertaking. And fifth, promotion of collective bargaining. Okay. The Trade Unions Act provides for the procedure of registration of a trade union, and the Industrial Disputes Act provides for the procedure of collective bargaining of the trade union with the management. What is an industrial dispute? An industrial dispute, as per section 2, all definitions in the Industrial Disputes Act are mentioned in the section 2 of the Industrial Disputes Act. Okay. So the industrial dispute means any dispute or difference between workmen and employers, between employers and employers, between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment or terms of employment or conditions of labor of any person. We discussed this in the last class, that this is the definition. Now, there are certain exceptions to this rule. First, an industrial dispute doesn't include personal quarrels, grumbling or agitations. They have to be connected with the employment or non-employment or terms of employment. So they cannot be that if someone says go to hell to me, that does not mean that I can raise an industrial dispute for it. That might be a personal dispute. He might not be my best friend. But even then, I can't raise an industrial dispute for that matter. It has to be connected with the employment or non-employment. Secondly, industrial disputes can be initiated or continued by legal heirs after the death of a workman. Sometimes accidents happen. There are hazardous machinery at times, and workmen might even lose their lives. Sometimes they lose vital organs, sometimes they lose life in unfortunate tragedies. So the legal heirs, the children and the dependents, can also carry on the industrial dispute on behalf of the workman, the deceased workman. And thirdly, employer's failure to keep its oral assurance shall not be regarded as industrial dispute. Alright, which is why trade unions have the power to enter into contracts. They need to get written contract signed. You cannot simply say, इसने तो मुझे बोला था, that he simply told me that they will increase wages next Diwali. That is not how it works. You will have to get something in written, and only then will you be liable. We will discuss this further when we discuss the Standing Orders Act in the 6th class. Okay, so this is the definition of industrial dispute, and these are the 3 exceptions or explanations to the definition of industrial disputes. Alright, let's discuss the applicability of the Industrial Dispute Act. The Industrial Dispute Act extends to the whole of India and applies to every industrial establishment carrying on any business, trade, manufacture or distribution of goods, irrespective of the number of workmen employed therein. For all others, you might see 10 workers, 20 workers. Now in the new labor codes, we will discuss that later, there is a limit of 40 workers. But the Industrial Disputes Act as it stands today does not have any limit on the number of workmen. Every person employed in an establishment for hire or reward, including contract labor, apprentice, part-time employees, to do manual, clerical, skilled, unskilled, technical, operational, supervisory work is covered by the Act. All of them can raise an industrial dispute. Casual workers and part-time workers are also workmen for the purpose of the Industrial Disputes Act. This Act does not apply to specific persons who are not workmen. These are persons who are in managerial or administrative capacity, persons engaged in supervisory capacity, and drawing more than 10,000 per month as salary. So if there is a factory floor supervisor, let's say, floor supervisor is the lowest rank normally in a shop floor management for any kind of worker. They are barely above the worker. So they can't be called manager. They can't be, if their terms of employment are violated, then they are also capable of raising an industrial dispute. However, only as long as they are not earning more than 10,000. If they are earning 8,000 or 9,000 rupees per month, then they can raise an industrial dispute as a workman. Or people executing managerial functions and persons subject to Army, Air Force or Navy Act, or those in police officers or prison officers. Okay. So basically security forces, people earning 10,000 or above, or those in managerial or administrative capacities. These 3 classes will not be considered as workmen for the purpose of Industrial Disputes Act. The Industrial Disputes Act is applicable to all existing industries not for dead industries. This was very big a problem, especially during the Sikh Industrial Companies Act, the SICA, was in force. Now the Insolvency and Bankruptcy Code is in force, and this problem does not arise anymore frequently. The workman can also raise a claim for compensation even from insolvent companies. However, the provision of Industrial Disputes Act has not been amended. So once an industry is closed, then you cannot do anything. No recourse. You need to act before your rights are completely taken away. Even after, in an IBC, insolvency proceeding, if the industry has been sold off to another debtor and the workman did nothing, then they lose their rights afterwards. This is not applicable to permanently closed place of employment, places which have faced closure. Okay, closure is permanent closing down of the place of employment, whereas lockout is temporary closing out of place of employment. All right. Let's come to some definitions. Firstly, we come to strike. Strike is a very powerful tool used by trade unions to get its demand accepted. It means quitting of work by a group of workers for the purpose of bringing pressure on their employer to accept their demands. That if they don't work, the industry will lose money, and therefore they want the employers to understand their pain. If the employers don't understand their pain, they will cause pain to the employer in terms of economic distress by reducing the productivity of the company. So this is one way of inducing pressure. The legal definition is strike means a cessation of work by a body of persons. Cessation means stopping. So strike means cessation of work by a body of persons employed in any industry acting in combination or a concerted refusal or refusal under a common understanding, who are or have been so employed or continue to work or to accept employment. Alright, so please understand, this is only, strike only means collective action. I can't stop working one day and say that I am on a strike, then you are only on a leave. Only when there is a concerted effort, a concerted refusal under a common understanding, that if 5 people fall sick simultaneously, that is not a common understanding, that is simply a coincidence. But if they fall sick, if they stop working because they don't want to work in relation to their employment, then that is a strike. There are different types of strikes. Strikes can be of different types, such as, firstly, economic strike. Economic strike is when members of the union stop work to enforce their economic demands, such as wages, bonus, other conditions of work. Basically, you stop work completely for the purpose of wages or demands. So first is the action that we look at, and then we look at the motive. Okay. So the action in economic strike is stopping work, and in the motive is for better work conditions and wages. Second is sympathetic strike, where members of a union collectively stop work to support or express sympathy with members or other unions who are on strike in other undertaking. For example, if certain textile mill workers have been retrenched wrongfully, then workers in a jute mill might still stop working because they want to express sympathy for their fellow workers. So in this case, the action is to stop work, whereas the motive is to express sympathy with other workers, because they also understand the plight of those, the pida of those who have been let go of. The third is a general strike. A general strike means a strike by members of all or most of the unions in a region or an industry. It may be a strike of all workers in a particular region to force demands common to all workers. It may also be an extension of a sympathetic strike to express general protest by the workers. Let's say some female workers were harassed by the people who have by the owners of any factory. So the workers might go on strike and other workers might also join, because it's possible that sexual harassment is common across the industry. So to raise awareness or to raise sympathy that finally sexual harassment will not be tolerated, this can happen across industries. So that is a general strike. Here also the action is to stop work and the motive is large scale protest for regional purpose. Let's say in one state the state government has got some policy which is against labor, so then there can be a general strike, let's say against state government policy or any other policy. The next is tool down, pen down, sit down or stay in. All of these are called tool down strikes. When workers do not leave their place of work but stop work, they are said to be in a sit down, stay in or tool down strike. It is all the workers remain at their workplace and also keep control over the work facilities. So they might come to the assembly line but they will not start working. So this paralyzes the entire industry or the workplace, and the employers have to listen to the workers. They can't even lock out because the workers are already in position. So the action here is to control the workplace and stop work, and the motive could be any of the above. Sympathetic, but normally this is for economic purposes. The last is slow down strike. Employees remain on their jobs in this type of strike. They do not stop work but restrict the rate of output in an organized manner. They adopt go slow tactics to put pressure on employers. Here the action is to slow work. Some people might have heard of the Japanese method of striking, where people work even harder, that they produce more output so that the management realizes that they have been too harsh. That is not the norm in India. In India, normally what they resort to is the slow down strike, so that there is economic distress on the employer, so that they relent to the demands of the workers. Then another method is picketing. Picketing is when workers are dissuaded from reporting for work by stationing certain men at the factory gates. If picketing does not involve any violence, it is perfectly legal. Those who have studied freedom struggle will realize that Gandhiji supported picketing, especially outside of liquor shops. You basically discourage people to enter. So picketing outside a factory is when you discourage the factory workers from going in. It is basically a method of drawing attention to public towards the fact that there is a dispute between management and the workers. Sometimes this can also mean dissuading customers from going into a shop, which can harm the business of the shopkeeper, which is very bad for the business. So therefore, the shopkeepers or the employers have to take care. So this is what is picketing. Then we come to Gherao. Gherao is a Hindi word which means to surround. Gherna, if you have heard, is basically the word for Gherao. The term Gherao denotes collective action initiated by a group of workers under which members of the management of an industrial unit are prohibited from leaving the business or residential premises by workers who block the exit through human barricade. So if this is the manager, this is the factory premises, then workers will form a human barricade and prevent the management from leaving until their demands are heard. Gheraos have been criticized both legally and morally. Legally, this amounts to wrongful restraint, which is an offense in the Indian Penal Code, that you don't allow people to move in the direction that they want to, and you wrongfully confine them. That is why courts have also held it as an illegal action. Morally also, the Gheraos tend to inflict physical duress, that they might starve, the management might starve, they might be ill, or their family might be worried. They also create law and order problems. So morally, a Gherao is to pressure someone into agreeing demands. That is also unjustified because this leads to coercion. Coercion is not from free consent. A person who is Geraud is also subject to humiliation. So this is not one of the recognized ways of collective action. The National Commission on Labour has held it as an unfair and illegal action. You cannot resort to a Gherao for any kind of demand. Then there is a lockout. A lockout is declared by the employers to put pressure on their workers. It is an act on part of the employers to close down the place of work until the workers agree to resume work on terms and conditions specified by the employers. Let's say if the workers want to leave early or they want more breaks, then the employers might also get irritated sometimes. So they will stop the work, they will say then don't come, don't enter. Then the workers will also lose their employment for the day. So lockout is also one way of the management putting pressure on the employees, the workmen. Industrial Disputes Act 1947 defines lockout as a temporary closing of a place of employment or suspension of work or refusal by an employer to continue to employ any number of persons employed by him. Lockouts are generally declared to curb the activities of militant workers. Lockout is declared as trial of strength between management and employees. That this is one of the ultimate face-off, that the management is not willing to engage with someone. Why will the management want to destroy their own economic output? It's normally when there is a much bigger threat, such as militant workers, revolutionary trade unionists who want to overthrow capitalism, etc. They create a major threat for the industrialist class. They restrict economic activity, and ultimately the management sometimes has to resort to lockouts also. The Industrial Disputes Act we saw seeks to pose a restriction on strikes and lockout. So Section 22 provides for a specific prohibition on strikes and lockouts in case of public utility services. We will discuss what this is. And Section 23 of the Industrial Disputes Act provides for a general prohibition on strikes and lockout if an adjudication proceeding is going on in an arbitration or labor court, and in some cases even in a conciliation proceeding, but in other cases the declaration of strike or lockout is fine if only a conciliation is going on. So these are the two restrictions that we will discuss now under the Industrial Disputes Act. So the specific prohibition on public utility services under section 22 provides that no person employed in public utility service shall go on strike, same for lockout, without giving a notice in the prescribed manner within 14 days of giving such notice of strike. It means date of strike should be after 14 days from the strike notice and after 6 weeks from the date of notice. It means that strike should be within 6 weeks from date of notice. So 2 weeks to 6 weeks is the limit before the expiry of the date of strike specified in any such notice, during the pendency of any conciliation proceeding, and after 7 days from the conciliation proceeding you cannot go on strike. So these are the certain conditions that you can only give notice, and within 2 to 6 weeks of the notice you have to go on strike, and you can't go on strike during a conciliation proceeding. Please note that these provisions do not prohibit the workers from going on strike but require them to fulfill the conditions before going on strike. These provisions further apply to public utility services only in case of strike or lockout. For other industries, prior notice is compulsory by employees or by management respectively to the government also. So it's not that you have to notify only the management, you have to notify the government mandatorily. As per the Industrial Disputes Act, the appropriate government may declare any industry specified in the first schedule of the ID Act to be a public utility service. Okay? And whenever something is declared a public utility service, only then section 22 for notice becomes applicable. So you can be declared a public utility service for a period of 6 months by issuing a notification in the official gazette, which may extend from time to time not exceeding 6 months, if in the opinion of the appropriate government public emergency or public interest requires extension. So for state transport services or electricity services, sometimes they are declared as public utility service so that you can prevent a strike immediately. They may be carried out by public companies as well as business corporations. So public and private sector can both be declared as a public utility service. We saw in the COVID-19 that all ambulances, all transport services were declared as public utility service, even for private entities in many states, to ensure oxygen supplies were continued. So that is one example of how to declare something a public utility service. This is different from a controlled industry, which is also defined in the Industrial Disputes Act, which says this is one which is controlled by the union government and has been declared to be a public interest by a central law. So a controlled industry is one where the appropriate government only means union government. For other cases, it will depend whether or not appropriate government is state government or union government. But in cases of controlled industry, it can only be the union government. They are declared by central law to be in public interest and to be controlled by the union government only. Normally, strategic minerals, banks, these are considered as controlled industries or were considered prior to the LPG reforms specifically. There is a general prohibition on strikes and lockout in section 23 of the Industrial Disputes Act. It imposes general restrictions on declaring strike in breach of contract in both public as well as non-public utility services in the following circumstance. Mainly, during the pendency of conciliation proceedings before a board of conciliation, till expiry of 7 days after conclusion of such proceedings. You cannot declare a strike during the pendency and 2 months after the conclusion of a labor court, tribunal or national tribunal. Similarly, 2 months after conclusion of arbitration and during any period in which settlement of award is in operation in any matter covered by the settlement of award in a conciliation proceeding. In a conciliation proceeding, you get a settlement. So, whenever any form of adjudication or conciliation is going on, you cannot declare a strike within a reasonable amount of time, which is 2 months for adjudication and 7 days for conciliation. Otherwise, this will defeat the purpose of going for settlement. Then if you are going to apply pressure tactics ultimately, then there is no point. Why should the management also deal with you? Because you are also not agreeable to their attempts. So that is why there is a general prohibition. If there is an illegal strike, then the employer can cut wages. Then they can declare that the persons were absent from work, and for long periods you can take disciplinary action also. So that is the threat that a worker faces, that they will lose their job if the strike is declared illegal. Therefore, they don't try to take too much panga. They try to maintain the legality of their action on their own, because they also don't want to lose their job. They want better living conditions, they want better working conditions, they want better wages, but they don't want to violate the law and to lose their job, because that's their means of livelihood ultimately. So people follow the law because of their own self-interest ultimately. Industrial disputes also concern dismissal and discharge. Whenever an employer discharges, dismisses, retrenches or otherwise terminates the services of an individual workman, that can be an industrial dispute. Any dispute or difference between that workman and his employer connected with or arising out of such discharge, dismissal, retrenchment or termination shall be deemed an industrial dispute, whether or not other workman or union workman is a party to the dispute. So it can be a single person dispute also. It is not necessary that only unions will take care of the trade dispute. Individuals can also follow their own trade dispute and fight their own battles without any external assistance. All right. Now, what is a discharge? What is a dismissal? The discharge refers to termination of services due to any reason, including retrenchment, after following the provisions of Industrial Disputes Act. An employee may be discharged from service for misconduct after holding disciplinary action, but a discharged employee shall be eligible for unpaid benefits from the company. For example, gratuity or back wages. All of these are still owed to the person even if they are discharged from service. However, dismissal is made for such gross negligence, the gravity of offence is beyond tolerable. For example, creating safety hazard or corruption as a bank clerk or other such actions which are not forgivable. An employee dismissed will not be paid gratuity and unavailed benefits. So let's say a cooperative bank fires one of its cashiers. The cashier goes to court saying that I was discharged and I need to be paid my benefits. The cooperative bank will say no, he was dismissed because of, let's say, charging bribe from certain people, from the rural people. And if it's found that it was ultimately a dismissal, not a discharge, then the cashier will not be eligible for getting any money back. So this is the main difference between discharge and dismissal, that discharge both require a disciplinary proceeding, but dismissal is more grave. Dismissal is unforgivable. Discharge is that you don't want someone in your company because they are not working right. Dismissal is that someone is bad, that they try to harm the company. Now we come to layoffs. Sometimes employers have to let go of their employees because of lack of work, low cash reserves, or any other reasons. Layoff means the failure or refusal or inability of an employer on account of shortage of coal, power or raw material, or accumulation of stocks, breakdown of machinery, natural calamity, or for any other connected reason. Basically, when the employer cannot, not that they don't want to, but that they cannot because of some actual reason, if they cannot give employment to a workman whose name is borne on the muster rolls. Muster rolls is basically a register of employees, and who has not been retrenched. Retrenchment we'll discuss later, but if none of these conditions have been met, then if the employer is still unable to provide employment to their workers, then that is called a layoff. Layoffs are different from retrenchment in many ways, but that in a layoff you're incapable for lack of opportunities, whereas in retrenchment you're incapable because of low profits. So that is a major difference between layoffs and retrenchment ultimately. However, the new labor codes have a very different approach. Earlier, any industry with 100 employees or more would have to give notice to the appropriate government that has been shifted to 300 employees now. Less than 300 employees, you don't have to give any notice for layoff or for retrenchment. You can work as you want. This is to promote ease of doing business. And the technical provisions of the Industrial Disputes Act, especially Section 25C was the section which related to layoffs and the notice that has to be given, etc. The employer had to prove, that any of these five had occurred, that there was some connected reason because of which employment could not be provided. Otherwise, they had to pay a fine to the government. So that was considered a very restrictive step for doing business, because sometimes there are reasons other than these reasons for which you cannot provide employment. Now this is an act from 1947, being applying it 75 years later is not fair upon the changed working conditions. That lack of power, shortage of coal, these are not the main reasons why one would like to lay off their workers sometimes. So these provisions have now been amended. We will discuss them in the later classes, what are the new provisions. So, but as a consequence, in this class we shall not discuss the technical provisions of layoff. Similarly, we will also not discuss the technical provisions of retrenchment. But it is important to know the definitions. So, what is retrenchment? Retrenchment is something akin to downsizing. When a company or government goes through retrenchment, it reduces outgoing money or expenditure or redirects focus in an attempt to become more financially solvent. Retrenchment as the termination by employer of service is the termination by the employer of the service of a workman for any reason whatsoever, but does not include voluntary retirement of the workman, punishment by way of disciplinary action, retirement on reaching age of superannuation if the contract concerned contains a stipulation in that behalf. Let's say it says after 60 years you cannot work, then once you reach that age you are called superannuated. Termination of service of the workman as a result of non-renewal of contract between employer through its expiry. This is called fixed term employment. If contract employment cannot be retrenched, they are simply not renewed. And last is termination of the service of a workman on grounds of continued ill health. Any of these five reasons for removing someone from service is not retrenchment. Retrenchment is something outside of these four. Okay. So as we discussed, basically it is the downsizing, that if you discharge, if you dismiss someone, if someone retires, takes voluntary retirement, or takes too much sick leave and you can't keep them on your muster rolls, that will not be retrenchment. But if you fire someone because you can't afford to keep them anymore, then that is called retrenchment. So these were the major provisions. The Industrial Disputes Act provides for a major dispute resolution mechanism. Various systems are provided for in the Act, such as the Works Committee, the Conciliation Officer, the Board of Conciliation, the Courts of Inquiry, Labour Courts, Industrial Tribunal, National Tribunal. These are provided for in the Act. Outside of these, there is also a provision for arbitration. It is not provided for in the Industrial Disputes Act specifically, but it is allowed that the trade union or workman can go against the employer via arbitration. So we will also be discussing arbitration in the end. All right. Let us briefly discuss all of these dispute resolution provisions. First is the Works Committee. The Works Committee is a committee consisting of representatives of employees, employers and workmen. The Works Committee is a forum for explaining the difficulties of all the parties. The function of Working Committee or Works Committee is to ascertain grievances of employees and to arrive at some agreement for day-to-day problems. So there are nominees of the employers and the nominees of the workers, and this Works Committee tries to fulfill the gap in understanding between the management and the workforce. The committee is formed by general or special order by the appropriate government in an industrial establishment in which 100 or more workmen are employed or to have been employed in any day preceding 12 months. Now this has been changed to 300 employees in the new Industrial Relations Code. All right. So this is a committee that is constituted by the government, that how many representatives should be there from each side, how many times will you sit. All of this is specifically decided by the government, and then there is an order by the government for a Works Committee in large industrial establishments. Then we have the Conciliation Officer. The government may appoint such number of conciliation officers as it thinks fit. The main objective of appointing conciliation officer is to create congenial atmosphere or harmonious atmosphere within the industry and reconcile the dispute of workers and employers. He may be appointed for specified area or for specified industries in a specified area, or for one or more specified industries either permanently or for limited time. So that is upon the government to decide for what purpose they want the conciliation officer. The duty of the conciliation officer is not judicial but administrative. He has to hold the conciliation proceedings, investigate disputes, do all such things as he thinks fit for the purpose of inducing the parties to arrive at a fair settlement. So he is not going to decide what is right and wrong. He is only allowing the parties to arrive at a fair settlement on their own. So he has to understand the grievances of the parties, and then he has to ensure that the parties come to a settlement. The conciliation officer is entitled to enter an establishment in which the dispute relates after reasonable notice, and to call for or inspect any document which he may consider relevant. He has to send a report and memorandum of settlement to appropriate government, that he has to provide a report of what all work he has done. The report by the conciliation officer has to be submitted within 14 days of the commencement of conciliation proceeding, or shorter period as may be prescribed by the appropriate government. This is basically that within 2 weeks the dispute should be resolved. Otherwise, there is no point in conciliation. You can't have conciliation going on for months and months altogether. So this is just one officer. If larger conciliation is needed, we have the Board of Conciliation. Okay. So the Board of Conciliation may also be constituted by the government. Whenever I say government, it always means the appropriate government. This is the only way the Industrial Disputes Act has defined most of its provisions, that government means appropriate government. For the settlement of industrial disputes, they may appoint a Board of Conciliation. The composition of the board is that there shall be one chairman and 2 or 4 other members in equal numbers representing the parties. to the dispute. So either 2 or 4, where there is 1 or 2 from each side and one chairperson. The chairperson shall be an independent person, a neutral third party. The settlement has to happen within a time limit. The Board of Conciliation has to bring about a settlement to the dispute. The board must submit a report within 2 months and mention the steps taken if no resolution could be made. That even if the Board of Conciliation fails, then they have to submit within 2 months any reports that they have, what work they did. Then we have a court of inquiry. A court of inquiry has independent members only, not equal representatives. Okay. To conduct any fact finding or inquiry. Let's say the worker said that there was an accident, but that was because of the lack of fencing. So the workers say there was no fence near the machinery. The management says that the accident happened because workers were drunk in the factory. Now it is upon the fact finding committee or the court of inquiry to determine what is right and what is wrong. It has to submit a report in 6 months, because if a court of inquiry has happened, then it will take a judicial step. The court of inquiry has the same power as a civil court under the Civil Procedure Code to enforce attendance of any witness or call any document for inspection. The government has to publish the findings of the report in 30 days of submission of the report. So this is a much more formal procedure. Beyond this, we come to the labor court. The appropriate government may constitute a one-member labor court for adjudication of industrial disputes relating to any matter specified in the second schedule. The first schedule is public utility services. The second schedule is matters specified for industrial disputes. Only for large scale matters will there be a labor court. The qualifications of a labor court judge, especially under a central law, because Industrial Disputes Act is a central law, is that he is or has been a judge of the High Court. He has he has been a district court judge for at least 3 years, or additional district judge, or he has held any judicial office for not less than 7 years, or he has been the presiding officer of a labor court under a state act for not less than 5 years, and he must be independent and not attain the age of 65 years. So he should not have an interest in the dispute, he should not have a connection with any of the parties, and he should not be 65 years of age. After labor court, there are tribunals. The government may set up industrial tribunals or national tribunals at the state level and the national level. This can also be a regional tribunal and the national tribunal. The government may also appoint assessors who are independent experts to advise the tribunals. The tribunals perform all functions of regular court for specialized purposes. However, judges can be technical experts also. It is not necessary that judges are only legal experts. They can be labor law experts, they can be labor law professors. That is upon the government to decide. The last is arbitration. Arbitration is also one of the means to settle labor disputes. A neutral third party is appointed as an adjudicator for the points of reference to the dispute. Here the two parties decide the subject matter, that these are the 1, 2, 3, 4. These are the 3 points that we need to decide. Only on these points will there be a decision. Any odd number of arbitrators can be appointed. It's not necessary that it's 1. It can be 3, it can be 5, it can be 7. It's odd number so that there is always a majority decision, right? That you can't say you can't have a 2-2 split or a 1-1 split. You can only have a proper majority so that the dispute is decided in finality. The arbitrator conducts private proceedings for industrial disputes and gives an award. The award is binding on all persons. Just like any other arbitration, a labor court arbitration also works this way. So this was the Industrial Disputes Act. Let us discuss some previous year questions. Firstly, which one of the following is the process in which representatives of workmen and employer involved in an industrial dispute are brought together before a third person or group of persons who facilitate through mediation to reach a mutually satisfactory agreement? A. Arbitration. B. Adjudication. C. Conciliation. D. Collective negotiation. In arbitration, there is an adjudication by a private party. In adjudication, there is adjudication by judge. In conciliation, there is a third party led mediation. And in collective negotiation, there is only two parties, trade union and management. So the answer is C. Conciliation. Next question. What is a controlled industry? A. Any industry, the control of which by the union has been declared by any central act to be expedient in public interest. B. Any industry, the control of which by the state has been declared by any state act to be expedient in public interest. C. Any industry, the control of which by municipal bodies has been declared by municipal rules to be expedient in public interest. Or D. Any industry, the control of which by the state has been declared by a central act to be expedient in public interest. We discussed this. A controlled industry is an industry where the union has control has been declared expedient by a central act. So the answer is A. Okay, let us discuss one last previous year question. Match the list 1 and list 2 and select the correct answer using the code given below the lists. So list 1 says A. Closure, B. Workmen, C. Strike and D. Lockout. And list 2 says 1. Permanent closing down of a place of employment. 2. Person employed in any industry to do skilled, unskilled or manual work. 3. Temporary closing down of a workplace by the management. And D. Cessation of work by employees. So closure we studied is the permanent closing down of a place of employment. So A matches with 1. Workman is any person employed in any industry to do skilled, unskilled or manual work. So B is 2. Strike is the cessation of work by employees. We saw it is the stopping of work or slowing down of work by employees. So C is 4. And lockout, D, is temporary closing down of a workplace by the management. So D is 3. Hence, if you see the answer, it is option A. A matches with 1, B matches with 2, C matches with 4 and D matches with 3. Okay. So the answer is A. Thank you. Hello everyone. Welcome to Industrial Relations and Labor Law for EPFO. This is the 5th class. Today we shall discuss the law on wages and remuneration. Alright, let us begin. So these are some of the acts, the laws that we shall be discussing today. Firstly, the Minimum Wages Act of 1948. Second, the Payment of Wages Act of 1936. Third, the Payment of Bonus Act 1965. Fourth, Equal Remuneration Act 1976. And the Payment of Gratuity Act 1972. We shall be discussing their applicability, the methods, systems notified within the act, and any definitions, if there are any major definitions provided in the acts. Okay, these are the few metrics to take note of. So first we have the Minimum Wages Act of 1948. This act was passed to prevent the exploitation of labor by underpayment of wages. Basically, payment of abysmally low wages was deemed to be similar to the horrifying act of slavery and forced labor. So we know that before any formal law on this topic, the landlords, industrialists would pay very less. They would either pay by food sometimes, or they would promise something and not give payment, or they would simply take the labor and then give whatever they wanted. They could give 2 annas, they could give 1 rupee at times, depending on how happy they were feeling, but they did not feel it was the obligation or the earned right. The earned right of the workman to take wages. So this led to a lot of exploitation of labor. So by the time we became an independent nation, the experience with colonial rule and indentured labor was deeply entrenched in the hearts and mind of the people. Indentured labor was a practice where colonial authorities, the merchants, would sign contracts with workers that for 20 years we will pay you XYZ wage, and then they would ship the worker to another colony, let's say Caribbean, Jamaica, West Indies. All of these have huge populations. Mauritius, all of these had indentured labor systems. So as a consequence, there was a lot of exploitation under the name of contract law. So contract was not enough. It was intended that there has to be legal protection under any cost for the exploitable illiterate workers. Thus, the provisions of the Minimum Wages Act are intended to achieve the object of doing social justice to workmen employed in scheduled employments by prescribing minimum wage rates for them. Please remember, this act is applicable to the organized sector only. It is not applicable to informal or unorganized sector. Okay, moving on. So there are 4 types of wages normally in the economic theory of wages. First is the subsistence wage, where the bare minimum needed for mere sustenance of food expenses is covered, that you will only get to eat enough to survive and for nothing else. Your shelter, your medical expenses, all of these are not covered. So this is the absolute minimum that only the human body should be able to get by to the next day and nothing more. Then we have the minimum wage concept. Minimum wage is that should be payable to any unskilled labor as a human being so that they can survive with food, shelter and clothing. All the basic needs of a human being should be met is the aim of the minimum wage concept. We follow the Aykroyd formula. The Aykroyd formula is being used by the central government to determine the minimum wage according to the changed living standards. This formula was applied after the 7th Pay Commission. It is by a Western economist called Dr. Aykroyd, who uses consumption basket as well as inflation rate plus desired saving rate. All of these are considered in the Aykroyd formula. That is why presently the government has declared that they don't have any immediate plans of going forward with the 8th Pay Commission, that there shall be no 8th Pay Commission as of now, that they will continue to use the Aykroyd formula to determine the changes in dearness allowance. Dearness allowance is basically the cost of inflation that is paid over and above the wages to a worker. So the Aykroyd formula will now be used instead of wages. Okay. After this, we come to the concept of fair wage. Fair wage, according to the prevailing industry standard and based on actual level of skill set that an employee brings to the organization. So let's say an organization is adding, a worker is providing 80,000 rupees worth of value, but you're only paying him 5,000 rupees, even though the industry is paying 10,000. So that's an unfair wage. But even if you're paying them 10,000, that could also be an unfair wage. A fair wage might be something like 35,000 or 50,000, where the worker is also earning according to their capacity, to their actual level of skill set. That is fair for them also. It is fair on the employer that they earn some profit, but it is fair for the worker that they live by their actual level of skill set. Then we have the concept of living wage. We also discussed living wage while discussing the directive principles of state policy, that living wages are those which are sufficient to provide a worker with a life of dignity and decent quality, that you no longer have to worry about your education of children or your basic living or food expenses, some medical expenses are covered, etc. So you can live a life of dignity, basic dignity, through a living wage. So what are wages? The definition of wages as per the Minimum Wages Act is as follows: all remuneration capable of being expressed in terms of money which would be payable to a person employed in respect of his employment and includes house rent allowance, but does not include the value of, first, any house accommodation, supply of light, water, medical attendance, etc., any other amenity or service excluded by the government specifically by notification. 3. Any contribution paid by the employer to any pension fund or provident fund under any scheme of social insurance. Therefore, PF contributions are not counted for minimum wage. Minimum wage is supposed to be available instantly so that a worker can plan their immediate life. 4. Any traveling allowance or the value of any traveling concession or any gratuity payable on discharge. We will discuss gratuity later in this same class, but basically all of these expenses are those which are imputed or long-term expenses. So they will not be considered for the purpose of minimum wages. While computing minimum wages, you will not count these 5. There are other important definitions in the Act. First is the definition of a child. Child means a person who has not completed 14 years of age. Adolescent means a person who has completed 14th year of age but has not completed 18th year. And adult means someone who has completed 18 years of age. Okay. We will discuss the concept of age in multiple acts. Basically, you have to compare it with the Factories Act and the Child Labor Act at all times. So, these are the definitions of a child, adolescent and adult for 14 to 18 and 18 plus. Okay. So under the Minimum Wages Act, the government has certain powers to fix the minimum wages for every age group, be it adolescents, adults and apprentices. Who are apprentice? They are trainees who learn on the job. So for example, you might have seen that sometimes if an electrician comes, the electrician comes with a junior electrician. That junior electrician is an apprentice, that they are also paid a wage, but they are paid a lesser wage because they are also learning at present. And the master electrician is one who is teaching. Then the government may also fix minimum wages for different industries and sectors. For example, they fix rural agricultural labor wages, rural industrial wages, urban industrial wages. For sugarcane industry, they fix separate wages, etc. So they can fix different wages for different industries and sectors because the requirements, seasonality and profitability of every sector might be different from the other sectors. So you have to account for those differences also on the kind of labor that the worker has to do. Then the government may fix according to regions, that they might be different wages for hilly regions where generally everyone earns less, so the wages are low, whereas in plains the wages are much higher because there is more job. So therefore they can set different wages. Also in places where cost of living is cheaper, you can have a lesser wage. The government may revise minimum wages periodically, but not exceeding 5 years. They mandatorily have to revise within 5 years. But within 5 years, they can do it at any time, be it 4 months, 6 months, 2 years, etc. Okay. Now we come to the procedure for fixing minimum wages. The appropriate government, we discussed in the last class that appropriate government here means state government or central government depending upon which government is controlling which industry. The appropriate government may fix wages, firstly, based on hourly, daily, weekly, or monthly rates that depends upon the industry, upon the kind of workman, etc. Secondly, they can fix in cash. However, it may also permit wages in kind depending upon custom. For example, in the sugar mills industry, the turnaround period is very high. So the UP government last year allowed them to pay in sugarcane, that you can pay your sugar laborers in sugar and sugarcane if you have nothing else for right now. Then the government can fix wages for overtime on an hourly basis. Overtime has to be on an hourly basis only unless fixed otherwise by the government. Because if you're asked to stay for two extra hours every day, you cannot pay for 10 days at the end. You have to pay for the number of hours. And how much per hour will you be paid extra shall be determined based on the rate set, but normally it is double the hourly rate normally. Okay. And then they can also fix wages for different classes of labor if the same employee performs 2 or more tasks. For example, if in a cashew factory there are 2 jobs of cleaning cashews and processing cashews, and if someone is doing both jobs, then there could be different wage rates for both of these. So the government can, if there are major categories, they can fix the wage rates for different classes of labor, especially if the same employee performs 2 or more tasks. Now we come to the procedure. There are 2 ways to do this. First is the committee method and the second is the notification method. Let us discuss both of them. The committee method is basically one where committees and subcommittees may be appointed by the government, the appropriate government, whatever it is, to calculate the minimum wages for different categories. So they will inspect ground realities. If there is too much effort needed, labor needed, time needed, etc., they will inspect ground realities and ultimately come up with a recommendation. The recommendation of the committees shall become effective once they are published in the official gazette notification. So it is still the government's power to accept the recommendation or to reject the recommendation. What will this committee be composed of? This committee will be composed of equal number of members from representatives of employers and employees both. Okay. And 1/3 of the total members shall be independent, but not exceeding 1/3. So at most you can have 1/3 employers members, 1/3 employee members, and 1/3 independent. You can also have, instead of this 1/3, you can also have 2/5 or 40% members from employers and employees, and only 20% of these members will be independent. This is also possible. The chairman shall be appointed from one of the independent members only. So you can have members of the committee as representatives of employers and employees, but the chairperson shall only be an independent person. This ensures neutrality in the process. The second method is the notification method, wherein the advisory boards come in. Okay. So the appropriate government shall publish its proposals by notification in the official gazette for information of persons likely to be affected thereby. Then the appropriate government shall specify a date not less than 2 months from the date of notification on which the proposals will be taken for consideration. Then representations will be received, and the representations received will be considered by the government. The government will consider the advice of the advisory board for this purpose. So in this case, the government will propose minimum wages rate. Then the public will send its representations, and these proposal and representation will ultimately be considered by the advisory boards, the state advisory board and the central advisory board. All right. And only after that they will be done, and this consideration will take at least 2 months. You will give 2 months for the representations to be given. Okay. And after that the advisory boards will consider the reports. Now these composition, the advisory boards are constituted in a manner very similar to the committees that we discussed. The board shall consist of persons to be nominated by the central government, representing employers and employees who shall be equal in number similarly, and independent persons nominated by the central government not exceeding 1/3 of the total number of members. All right. One of such independent persons shall be appointed the chairman of the board by the central government. This is the Central Advisory Board under Section 8 of the Minimum Wages Act. The State Advisory Board under Section 7 is also on the same lines, that you will have equal employers and employees will be both equal, and about not more than 1/3 shall be the independent members. The chairperson shall be an independent person. This is the general composition of the entire committee method as well as the advisory board method. Now we come to the Payment of Wages Act. This was passed prior to independence. This was to ensure the timely payment of wages to workmen of different categories. This act fixes responsibility on different industrial management posts for payment of wages, such as the railway officer or the factory manager or the contractor. Depending upon the specific stage, this act fixes the responsibility on these different positions for the payment of wages, so that ultimately someone can be held accountable. Otherwise, nobody likes to claim accountability when some wrongdoing happens. The Payment of Wages Act provides also for the types of deductions which can be made from the wages of a workman. If they have not done the work properly, then you can deduct wages also. Okay, so these are some of the aspects. Firstly, we come to the timely payment of wages. The first rule is that no wage period should be delayed beyond 1 month. You cannot have a 45 delay in payment of wages. Secondly, the wages of every person employed shall depend upon the industry. A. Any railway, factory, industrial or other establishment in which less than 1000 persons are employed shall be paid before the 7th day. So by 7 June, your salary for May should be received. Okay. Any other railway, factory or industrial establishment shall be paid before the expiry of the 10th day. So for 1000 plus people, we have 7 June. Otherwise, let's say for 300 people, you have 10 June as the maximum date, the 10th day of the next month, every month. So these provisions exist in the Payment of Wages Act for timely payment of wages. What are wages? According to the Payment of Wages Act, please remember that the Minimum Wage Act allowed for house rent as well as other remuneration. In this case, the wages include monthly wages, salaries and allowance, statutory bonus under Payment of Bonus Act, as well as any other payment by court orders, especially if the labor court has ordered something, that has to be followed in the normal definition of wages only. But this does not include or excludes first, house accommodation, supply of water, light or medical attendance, the same as the Minimum Wages Act. Secondly, voluntarily declared bonus out of profits. We will discuss that bonus has to be statutorily declared under Payment of Bonus Act and can also be voluntarily declared over and above the statutory amount. Third is travel expenses. Travel expenses are not considered wages for the purpose of Payment of Wages Act. Fourthly, contributions to Provident Fund. This is very similar to the entire provisions of the Minimum Wages Act. There also Provident Fund or house accommodation, medical expenses, travel concession, all of these were not counted as wages. There are some applicable deductions which can be validly deducted. Firstly, fines for any misconduct, wrongdoing, etc. Second, the deductions for absence, that if you're not in your position at the required time, then your wages can be deducted validly. Third is the deduction from damage to goods. That if you damage any machine or if you spill liquid etc. anywhere, you can be fined for that. and any deductions for recovery of advances made to workmen. Sometimes they need money for marriage, for medical expenses, so they might take advance payment that can be recovered without any issue in wages. What is not deduction? That these are not considered deduction for the purpose of payment of wages is the stoppage of increments or promotion, that only your current wages are counted, not what you were supposed to get after promotion. Secondly, demotion is not considered a deduction in wage, neither is suspension of the employee a deduction. All of these, if they are done in a legal format, they are not wrong or illegal for the employer to do. Now we come to the Payment of Bonus Act. The Payment of Bonus Act 1965, as the name suggests, only deals with bonus. Bonus pay is an additional pay given to an employee on top of his or her regular earnings. It is used by many organizations as recognition or regard to employees or a team that has achieved significant goals. Bonus pay is also offered to employees to improve morale, motivation, and productivity. But because a lot of bargaining power rests with the industrialists and there is information asymmetry, that workers don't know how much actually the enterprise is earning. That is why, to secure the rights of laborers to share profits of the enterprise, the Payment of Bonus Act was introduced. Okay. So the bonus is applicable for, the Payment of Bonus Act is applicable for every factory, every other establishment in which 20 or more persons are employed on any day during the accounting year. So even if you normally employ 17 people but hire 4 additional for the Diwali months when there is higher demand, even then you will be required to pay bonus, and you will be required to pay bonus to all of these, or at least the 17 which are ordinarily employed. However, government may, by provisions of the Act to any establishment, may apply the provisions of the Act to any establishment employing more than 10 persons but less than 20 after giving 2 months notice to the employer. Okay. So even for cottage industries, this can be made applicable, however, after 2 months notice, so that the employer can arrange funds. Okay. The Act shall not apply to the following classes of employees. Firstly, employees employed in LIC, the Life Insurance Corporation. Second, seamen defined in the Merchant Shipping Act. Thirdly, employees registered under the Dock Workers Act 1948. And fourthly, employees employed by an establishment under central, state government or local authorities. So basically, civil servants or government authorities, as well as merchant shipping, dock workers and LIC workers shall not be included under the Payment of Bonus Act. An employee can be disqualified from the benefits of bonus in the following cases. Firstly, if they are dismissed from service, then they will not be eligible for bonus. Secondly, if they have committed fraud then they shall be disqualified from receiving any bonus even if they have worked for the entire year. Thirdly, first is dismissed, then is fraud, then is riotous or violent behavior while in employment, such as creating ruckus or breaking property, damaging property. And lastly, for theft, misappropriation or sabotage of any property in the establishment. So in any of these cases, the workers can be disqualified from receiving bonus. There is a scope of the Bonus Act. Firstly, the minimum range, the employee shall be bound to pay every employee a minimum bonus which shall be 8.33% of the wages, basic pay plus dearness allowance earned by the employee during the accounting year. Thus, employer is bound to pay minimum bonus even if he suffers the losses during the accounting year. This also allows that if someone works for 4 months, they will get 8.33% for the 4 months, and if someone works for 12 months, they will get 8.33% for the entire 12 months, regardless of the profits of the enterprise. This is normally paid during Diwali. Only as a custom, in different states, there are different declaration times depending upon what festivals they are celebrating. Because festive season is also a time when you want to spend more. So you try to pay your employees at that time so that they can also enjoy with their family upon relevant festivities. The maximum bonus required or permitted under the Act is 20% of the wages earned by the worker during the accounting year. So you cannot pay more than that statutorily. You are not required to pay the bonus of 25% or even 21%. You are obviously allowed, but that is outside the Act. You don't have to call it a bonus. You can call it other emoluments if you want to. There is also a cap of the wages, that if someone is getting 7,000 rupees per month, then this will be calculated, bonus will be calculated on 7,000 rupees. On 6,500 rupees, it will be calculated on 6,500. But if someone is getting 7,500, then also the maximum monthly cap will be 7,000 rupees. How the bonus is calculated is slightly technical, so just keep this fact in mind, but beyond this, it should not be important from the point of view of syllabus. Okay. Now we come to the Equal Remuneration Act 1976. The chief motive of the Equal Remuneration Act 1976 is to provide for payment of remuneration to men and women on a uniform basis. In order to avoid discrimination against women and to treat the women in a fair and just manner, this act is brought into force. Basically, there is a huge gender gap. Even now, the gender gap in India is very high in terms of employment opportunities, and to avoid this gender gap in industrial work, where women were paid less wage for the same job, the Equal Remuneration Act came, which said equal pay for equal work. This is the principle. This principle is also discussed in Article 39D of the Constitution, that the state should ensure that there is equal pay for equal work for both men and women. So this principle was finally enacted through the Equal Remuneration Act of 1976. There are certain important definitions of this act. Firstly, what is remuneration? Remuneration means the basic wage or salary and any additional emoluments whatsoever payable either in cash or in kind to a person employed in respect of employment or work done in such employment if the terms of contract or employment were fulfilled. So basically, this is not just limited to wages, but suppose you are able to give house accommodation to all your male employees, but you are giving nothing to females, that is also discrimination. If you are giving water or break to your employees, that should also be considered. But this is only if they are actually performing, if they are fulfilling their job requirements. If someone is hired to pick 50 bags of rice every day, they are only picking 20 bags, then they will not be entitled to the benefits at the same scale, whether they are a man or a woman. Okay. The second definition is same work or work of a similar nature. This means work in respect of which the skill, effort and responsibility required are the same when performed under similar working conditions by a man or a woman. So, skill, effort or responsibility is same and the working conditions are same. So let's say if I am supposed to supervise 10 workers inside the factory shed, whereas someone else is supposed to supervise 10 workers out in the sun or in a very hilly region with a lot of natural disasters, etc., then that will not be considered similar nature of work. That will have different consequences. But for similar nature, the pay has to be the same. Okay. There are certain duties upon employers under this act. The first duty is that employers cannot discriminate on the basis of sex for deciding wages if the quality and nature of work is the same. If two different rates are prescribed based on differences in sex, then the higher wage rate shall be payable to everyone. If someone is paying 200 rupees a day to women and 600 rupees a day to men, then 600 shall be payable to everyone if that is the criteria. Secondly, employers cannot discriminate on the basis of sex even at the time of recruitment. Rejecting any potential candidate solely for their gender is an offense. So it's not that you will hire only men as a consequence. If the work can be done by men or women both, then the act requires that you will hire without any discrimination. There are social stigmas that still prevail. However, these are the provisions of the act which prohibit discrimination. Thirdly, employers must maintain a register of employees and wages paid. This can be checked by the employers ultimately, by the inspectors ultimately, and if someone is found to not comply, they can be penalized for the offense that they have committed. There are certain government agencies which come into play for the purpose of Equal Remuneration Act. First, there is an advisory committee. The advisory committee can be appointed by the central government to provide inputs on how to ensure compliance with the spirit of the law and to reduce the gender wage gap. Because it's not just the content of the law that someone should not discriminate, it's the spirit of the law that there should be no discrimination. That ultimately we reach a place in society where discrimination on the basis of gender, especially for equal amount of work, does not exist. Then the second kind of officials are the labor officers. The labor officers can be appointed for hearing and deciding cases whether the provisions of the Equal Remuneration Act have been contravened or violated. So the labor officer provides the first level of judgment. After this, you can go to industrial tribunals. Third, inspectors. Inspectors can be appointed who can check the registers maintained by employers and actually visit sites for on-ground inspection to check compliance with the law. So the inspector goes to the factory premises to check if there are violations. Then the labor officer can decide, and if there are multiple violations, the advisory committee can ultimately provide recommendations on how to end socio-economic discrimination using this data. This is the three-tier machinery normally within the Equal Remuneration Act that is provided for. The government can make use. In this case, the central government has the advisory committee. The state governments may have their advisory committee. It is not necessary. Alright. Last is the Payment of Gratuity Act. The Payment of Gratuity Act provides for gratuity, which is a lump sum amount given by the employer to employees at the time of retirement. It is like a token of appreciation for long service. So once you serve, let's say 20 years, you will get a loyalty reward by the company that you have worked for us for so many years. Here is a massive payment for that purpose. Applicability of the Payment of Gratuity Act is as follows, that it is applicable on every factory as defined in the Factories Act, every mine, oil field, plantation, port and railway. Besides that, every shop or establishment under the Shops and Establishments Act of a state applies where 10 or more persons are employed at any time during the year. Okay. Once the act applies, it continues to apply even if employment strength falls below 10. The same way as we discussed for the Bonus Act, the Payment of Gratuity Act also applies once and then sticks to the employer. Last, we have the fact that employee here means both managerial and administrative staff along with workmen. So in the Industrial Disputes Act, we had studied that workman is one who is earning less than 10,000 rupees per month and is not in managerial or administrative capacity. But in this case, for the purpose of payment of gratuity, even those employees which are in managerial or administrative capacity will be paid the bonus, will be paid the gratuity at the end of the gratuity period at the time of retirement. Now, gratuity is calculated through a formula. It is dependent upon the number of years served in the company and the last drawn salary. These are the two metrics. So the formula is N star B star 15 by 26, where N is the number of service years, B is the last drawn basic salary plus DA. Let's say Chandra worked for ABC Limited for 20 years. They earned 25,000 per month salary. Now, their gratuity will be 25,000 into 20 into 15 by 26, which is 5 lakh plus 5 lakh into 15 by 26. This will be approximately 2 lakh 88,400, something around this. Okay. So this you will get. I took a wrong figure. Had it been 26,000, it would have been easier to apply. But anyway, so the employer has the right to reject payment of gratuity to an employee if he or she has been asked to leave his or her own job due to any misconduct. Similar to bonus, that when you can get disqualified from bonus, you can also be disqualified from gratuity because of misconduct. There are certain eligibility criteria for the payment of gratuity. Gratuity shall be payable to an employee on the termination of his employment after he has rendered continuous service for not less than 5 years. Okay, minimum 5 years is needed. Either on superannuation, 2 on his retirement or resignation, or 3 on his death or disablement due to accident or disease, but minimum 5 years is needed. The completion of continuous 5 years shall not be necessary where the termination is due to death or disablement. If you are working for the company and you die midway due to an accident, etc., then 5 years is not needed. You can be directly paid the gratuity. In case of death or disablement by accident or disease, the employer is under obligation to pay gratuity amount to the nominee or legal heir, irrespective of the number of continuous years the service has been rendered. This is not because of the unfairness or lack of ease of doing to the business. This is because the family of the worker will need this much, that their financial concerns should at least be taken care of if their family member worked for a company and died in that company. And then this is the bare minimum that the company should take care of. For this purpose, gratuity has to be paid. There is a maximum cap on the payment of gratuity. According to the Payment of Gratuity Amendment Act 2018, the maximum gratuity payable has been extended to 20 lakh rupees against the earlier limit of 10 lakh rupees, which was set in 2010. And this is normally periodically revised because something has to be done due to changing standards. So later on it could also be extended to rupees 30 lakhs in the coming few years because cost of living has risen very much. But you cannot have an infinite burden. no infinite burden upon the employers to pay. Okay. Most central government, state government establishments are exempt from payment of gratuity because they are going to pay pension. Pension is not paid for most private companies, so gratuity is something that has to be paid to them. Let us discuss some previous year questions for this. First, who among the following can be appointed as chairman of a central advisory board constituted by the central government under the Minimum Wages Act 1948? A. One of the independent members of the board. B. One of the employer's representatives of the board. C. One of the employees' representatives of the board. Or D. A functionary of the central government nominated by the government. We had discussed that employees and employers' representatives are equal in number, and the independent members can be 1/3 at most, and the chairperson shall be from the independent members. So the answer is A. Second, the Ackroyd formula Dr. Ackroyd's formula is associated with the determination of A. Fair wage, B. Minimum wage, C. Living wage, or D. Real wage. We had discussed this is for minimum wage after the 7th pay commission. This formula has been adopted by the central government. So the answer is B. Minimum wage. Next question. What is the minimum period in which appropriate government shall review and revise the minimum rates of wages under the Minimum Wages Act 1948? A. 2 years, B. 3 years, C. 4 years, and D. 5 years. We had discussed that the government can review these at any time not exceeding 5 years. Not exceeding 5 years. Okay, so the answer is D. 5 years. Next question. What is the maximum amount of gratuity payable to employees under Payment of Gratuity Act 1972? A. Rupees 5 lakh, B. Rupees 10 lakh, C. Rupees 15 lakh, or D. Rupees 20 lakhs. We had just seen that the limit has been extended to rupees 20 lakhs. This was asked in the 2021 paper after the change was made. So please also be aware of any current affairs changes in labor laws. Okay, so these were the questions. Thank you. Hello everyone. Welcome to the 6th class for Industrial Relations and Labor Law. In this class, we shall discuss workplace conditions. Basically, we will discuss what are the minimum standards that every workplace must have in order to comply with the law. Okay, let us begin. In this class, we shall be covering 3 primary legislations. First is the Factories Act 1948. This act discusses what are the basic standards that a factory must have for hygiene, working environment, safety, timings, age of workers, etc. All of these are covered in the Factories Act 1948. The next we shall discuss is the Industrial Employment Standing Orders Act. This is also simply called the Standing Orders Act. This basically provides for the mechanism of formalizing conditions of work in large establishments. So this is the Standing Orders Act, and the last is the Child Labour Prohibition and Regulation Act of 2016. This, as the name suggests, is basically about prohibition of child labor, that no child can work, and in what circumstance can a child be engaged in work, and in what circumstances can an adolescent person be engaged in work. So we shall be discussing these three legislations in today's class. Let us begin. First, we come to the Factories Act 1948. The Factories Act 1948 was enacted. Please remember that all of these enactments were enacted from the period of 1946 to 1948, after the end of the Second World War, because of the huge labor uprising. There were many concessions that the labor had given to the British during the Quit India movement, and it was considered necessary that now the communists were very powerful across the world, and similarly the working movement had also grown very strong. So therefore a lot of concessions were needed. So you will see the Industrial Disputes Act, the Factories Act, the Minimum Wages Act, all of these were passed in the same time period because of this. Okay. The Factories Act was passed to ensure adequate safety measures and to promote health and welfare of the workers employed in factories. Okay. So safety measures and promoting health and welfare of the workers. These were the primary aims of the Factories Act. The Factory Act also provides for the growth chart and the blueprint of any factory that has to be approved. So once you have a blueprint, you can have a planned growth of any factory. This was to prevent haphazard growth of factories through provisions, because every plan had to be approved before creation of a factory. This also ultimately led to license Raj, that for everything, for building a factory you needed a license, for expanding the factory you needed a license, for hiring more than 100 workers you needed a license, for closing down a factory with more than 100 workers you needed permission, for every form of clearance, for expanding capacity you needed permission. So this was the beginning of the license Raj period, and this was done under the banner of protection of labor. Okay. The Factories Act covers all manufacturing processes and establishments falling within the definition of factory. We shall discuss what is a factory in the coming slides. This is also applicable to all factories using power and employing 10 or more workers, and if not using power than 20 or more workers. Okay. So this is the general applicability of the Factories Act 1948. Let us come to important definitions in the Factories Act. First definition is the definition of a factory. According to the Act, a factory means any premises including the precincts thereof. Precinct is boundary of a building. Any premises including precincts thereof. First, wherein 10 or more workers are working or were working on any day in the past 12 months and in any part of which is manufacturing process being carried on with the aid of power as is ordinarily so carried on. Okay, please ignore the legal language of the text. This is how laws are drafted, and this legal drafting was even more complicated in the 1940s, 1950s era, when a lot of British jargon was being used. So basically, this says that if 10 plus workers are employed and power is being used for manufacturing process, we will discuss what this is. Or secondly, where 20 or more workers are working or were working in the past 12 months in any part of which a manufacturing process is being carried on without aid of power. Okay. And then there is a note that a factory shall not include a mine subject to the Operation of Mines Act 1952 or a mobile unit belonging to the armed forces of the Union, a railway running shed or hotel, restaurant or eating places. Okay. So basically mines, army and hospitality. These three sectors and railways. All of these are exempted, and please note that it's only a railway running shed. For the rest of railway factories such as the ICF, the Integrated Coach Factory in Chennai, there the Factories Act will continue to be applicable. It is only for railway running sheds, mines, armed forces and hospitality sector where the Factories Act will not be applicable. Next definition is the definition of manufacturing process. Now, as per the Factories Act, a manufacturing process means any process for firstly making, altering, repairing, ornamenting, finishing, packing, oiling, washing, cleaning, breaking up, demolishing, or otherwise treating or adopting any article or substance with a view to its use, sale, transport, delivery, or disposal. Basically, any kind of processing activity of any article, anything for the purpose of creating, use, sale, or transport is called manufacturing process. Okay. Secondly, pumping oil, water, sewage, or any other substance. Thirdly, generating, transforming, or transmitting power. So the electricity industry is also a manufacturing process. Fourth, composing types of printing, printing by letterpress, lithography, photogravure, or other similar process of book binding. So publication is also a manufacturing. Sixth, Fifth, constructing, reconstructing, repairing, refitting, finishing or breaking up ships or vessels. So maritime industry will also be a factory. And sixth and lastly, preserving, storing any article in cold storage. So warehouses with cold storage are also a factory. Okay, all of these are considered manufacturing process. So if they are using power, then 10 plus workers, and if they are not using power, then 20 plus workers. Most of these limits I will discuss in the next class. They have changed in the new labor codes. Now let's come to other definitions. First, definition of a child. A child is any person who has not completed his 15th year of age. For Minimum Wages Act and for Industrial Disputes Act, it was 14 years. Here it is 15th year. Okay. An adolescent means a person who completes his 15 years of age but not his 18th years of age. Hence, he is someone who crosses the age of a child but is not an adult. Someone in the age group of 15 to 18 years. Then we come to young person. A young person means a person who is either a child or an adolescent. So basically both of these categories, if you club them, you will get the definition of young person. And last is an adult. An adult means a person who has completed his 18th year of age. This is common everywhere. It is only that Minimum Wages Act, Labor Act, all of these provide for 14 years for the age of child, whereas 15 years is what is provided for under the Factories Act. Okay. Now we come to the definition of worker. As per the Factories Act, a worker means a person employed directly or by or through any agency, including a contractor. So this includes a contract labor. Okay, with or without the knowledge of the principal employer, whether for remuneration or not, in any manufacturing process or in cleaning any part of the machinery or premises used for a manufacturing process, or in any other kind of work incidental to or connected with the manufacturing process or subject of the manufacturing process, but does not include any member of the armed forces of the union. Okay, so basically the workers shall include all purposes of work, whether they are directly in the manufacturing process or indirectly involved in the manufacturing process. You have to be counted as a worker. Also, if a worker is hired from agency, it is not necessary that they are being paid immediately. Okay, it is possible that the agency pays them a monthly salary and they are hired only for 2 days or 5 days a week, or for only for this small purpose. But if they are hired even for a limited time, they will be considered a worker for this purpose. Okay. Then we come to the definition of calendar year. A calendar year means the period of 12 months beginning with the first day of January in any year from the it is different from the financial year. Okay. The RBI decides the financial year. In India, it is March 31 to April 1 to March 31. Whereas in other places, it is for all other purposes, a calendar year is the normal calendar from 1st of January to 31st of December. Day normally means 24-hour period beginning at midnight. So this is how days to be calculated. And week means a period of 7 days beginning at midnight on Saturday night or such other night. Therefore, Sunday is the first day of the week as per the official definition in Factories Act. Alright. These are some definitions. The Factories Act requires certain facilities and conveniences to be present in all factories, that the factory should be kept clean, there should be arrangement to dispose wastes and effluents, ventilation should be adequate, reasonable temperature for comfort of employees should be maintained, that it should not cross 50 degrees Celsius or something which is unreasonable. Dust and fume should be controlled below permissible limits. Artificial humidification should be at prescribed standard level. Overcrowding should be avoided. Adequate lighting, drinking water, latrines, urinals, spittoons should be provided so that there is sufficient sanitation and workers don't contract diseases. Okay. And lastly, adequate spittoon should be added, which is something we covered. This was repetitive. So these are some of the facilities and convenience that are mandatory in every factory. Then we come to certain facilities which are needed in case of large factories specifically. So depending upon the size, which has been decided in different cases, different amount of facilities have to be provided. So following facilities are required to be provided by large factories. First, the ambulance room, if 500 or more workers are employed, then there has to be an ambulance room within the factory premises. 2. Canteen, if 250 or more workers are employed, it should be sufficiently lighted and ventilated and suitably located, because people will need lunch break and you cannot expect the entire workforce to bring a tiffin. So you need a canteen with some basic food at least. Okay. Third is a restroom or shelter with drinking water when 150 or more workmen are employed. Fourth is creche facilities if 30 or more women workers are employed, so that if women are required normally to take care of children, then to employ women you need to bring creche facilities. Okay. Full-time welfare officer if factory employs 500 or more workers, to ensure worker welfare is constant. Sixth, the safety officer if 1000 or more workmen are employed. The safety officer shall be in charge of looking over all hazardous machinery, and shall be accountable in case of industrial accidents. The entirety of the labor law is very, very keen on fixing accountability, because many times the criminal liability otherwise cannot be imposed upon anyone. The management says that we were not present, so we don't have the guilty mind for criminal intention, and the workers say that we were not at fault, the management is at fault. So ultimately it is very difficult to fix liability. At least for large factories with 1,000 or more workers, a safety officer ensures that there is accountability. There are some minimum conditions of safety that have to be taken care of. All machinery should be properly fenced to protect workers when machinery is in motion. This is the first. Second, hoists and lifts should be in good condition and tested periodically. Pressure plants should be checked as per rules. These will be notified by governments, appropriate government, depending upon the need of the hour. Third, the floor, stairs, means of access should be of sound construction and free from obstructions. Safety appliances for eyes, dangerous dusts, gas, fumes should be provided. All of these are checked periodically. Okay. Labor inspectors are authorized to go to the inspection sites and conduct raids to see whether or not these factory safety rules are met with it or not. These are directly statutory, these are present in the act, and underneath this the state government can have factory rules. Under the Factory Act you can have the factory rules. Okay. Fourth, worker is also under obligation to use the safety appliances. He should not misuse any appliance, convenience or other things provided. In case of hazardous substances, additional safety measure should have been prescribed. And the list of hazardous substances is provided for both in the Environment Protection Act as well as in different state factory rules. Adequate firefighting equipment should be available. To deal with the issue of industrial fires, you need to follow both the building code, commercial building code, as well as the Factory Act also provides for firefighting equipment. Seventhly, safety officer should be appointed if number of workers in factory are 1,000 or more. The qualification for safety officer is prescribed by the state government. Okay. The state government lays down the criteria on which you can appoint a safety officer, and these are the basic safety measures that you have to take. The working hours of workmen are also regulated under the Factories Act. If a worker works beyond 9 hours a day or for 48 hours a week maximum, okay, overtime wages are double the rate of wages payable. Secondly, the clause of double employment, that a workman cannot work in two factories. There is a restriction on double employment. Overtime wages are not payable when worker is on tour. That, let's say if they are traveling, so then they are out 24 hours a day, 48 hours in 2 days. that does not mean that they are considered for overtime wages. Total working hours including overtime should not exceed 60 in a week, and total overtime hours in a quarter is 3 months, okay, about 12 weeks, should not exceed 50. So over the course of 12 weeks you cannot have more than 50 overtime hours. Lastly, a register of overtime should be maintained. An employee working outside the factory premises, like field workers, etc., on tour outside headquarters, are not entitled to overtime. So, field inspection or site work, this will not be considered for overtime, but as long as you're on the job, that will be considered. These are only limited. Please understand, this is not applicable to field workers for the purpose that this is the Factories Act. This is applicable only for factories, not for work done outside of factories. Now we come to the provisions on leave. A worker is entitled in every calendar year annual leave with wages at the rate of 1 day for every 20 days of work performed in the previous calendar year, provided he had worked for 240 days or more in the previous calendar year. So, if you work for 240 days at least in the year, then in the last year, then in the present year, you are entitled to at least 12, or if you worked for 300 days last year, then you are allowed 15 annual leaves with wages. So your payment will not be deducted. This is called paid time off. Okay. While calculating 240 days, earned leave, maternity leave up to 12 weeks and layoff days will be considered, but the leave will not be earned on those days. Okay. So if someone has to work for 300 has to take leave for 240 days, and let's say for 84 days they were on maternity leave, that will still be counted to see whether or not 240 days are complete. Let's say if they were present in work for 160 days, I will erase all of this for ease. Let's say someone was off for 84 days because of maternity, okay, and they were present on the job for 160 days. Now they will be counted as 244 days for the purpose of calculating whether or not they were present. Okay, both of these will be added, but for the purpose of earned leave they will only count 160. So you are only getting 8 days of annual leave with wages because you were not physically present on the job. Leave can be accumulated up to 30 days in case of adult and 40 days in case of child. Please understand, in the Factories Act, the child is 15 years. So, and the limit is 14 years beneath which you cannot work. So, under the Factories Act, a child who is between 14 to 15 years is considered a child but can work. This is not allowed in any other act, it's only under the Factories Act. Next point, leave admissible is exclusive of holidays occurring during or at the end of the leave period. So if there is a Diwali, Holi, etc. during the period of leave, then that will be considered separately. You will not be deducted from your leaves. Wage for period must be paid before leave begins if leave is for 4 or more days. So if you pre-cash your leaves, that is possible and that is allowed. Leave cannot be taken for more than 3 times in a year. Okay, so you have to take a collective set of leaves and you can't be going on leaves for let's say 5 times. You have to take 3 bulk times at most. Application for leave should not normally be refused. That there can only be exceptional circumstances. These are minimum benefits. Please understand that these are what the law gives you. The law gives the worker. The employer can give additional benefits also. That is upon the employer. They should give, that will improve their working conditions as well as motivation. But this is the bare minimum that they have to provide. When we come to child employment, a child below the age of 14 should not be employed. The child above 14 but below 15 years of age can be employed only for 4.5 hours a day or during the night. He cannot be employed during the night between 10 p.m. to 6 a.m. So their night here means any time after evening. So from 4 p.m. to 10 p.m. he can be employed for 4.5 hours at most. Okay. He should be certified fit by a certifying surgeon. That there should be a certificate that is received from a medical officer. An adolescent is a person over 15 but below 18 years of age, is termed adolescent. He can be employed as an adult if he has a certificate of fitness for a full day's work from certifying surgeon. Okay, so the surgeon certificate is needed even for adolescents. An adolescent is not permitted to work between 7 p.m. and 6 a.m. There are more restrictions on employment of female adolescents also. Lastly, register of child workers should be maintained. You have to maintain a very specific record of which children and at what times they enter and exit the factory premises, because the children cannot otherwise be employed in factories at all. These were the provisions of the Factories Act. Now we come to the Industrial Employment Standing Orders Act. The Industrial Employment Standing Orders Act was passed to ensure there is stability in work conditions. Earlier, industrialists would employ workmen on very vague terms and then exploit the vulnerable and illiterate workforce using contract interpretation, because the workmen don't know what exactly the contract might be saying. Many of them might be illiterate, especially in the 1946 period when there was only 16 to 20% literacy, bare literacy. Then reading complicated documents would not have been possible for the workmen, so the industrialists could exploit. So the Industrial Employment Standing Orders Act required mandatory recognition to some standardized working conditions, that the employer will have to provide for some minimum work conditions. Then they would get approval, and this approval will be in the form of a standing order which cannot be varied, which cannot be changed. So therefore, there is a record with the government of what kind of work conditions the employer has promised. So under the Standing Orders Act, the employers have to get some terms of employment certified by the government so that workers can work under stable conditions. Certification is done by a certifying officer who is the rank of a labor commissioner. Okay. There are some mandatory details which the standing orders must provide for. First, that workman classification into categories such as permanent, temporary, on probation, etc. So the standing order has to provide what kind of workers are there. Secondly, the method of informing workmen about working hours, holidays, etc. That if 10 gazetted holidays exist, then where will you put the notice? This has to be provided. Third, attendance and conditions of granting leave. Will there be an attendance register, etc.? And how much attendance will be marked, from what time? Means of redressal for workmen or any other matter, such as a works committee if it exists, or let's say a grievance officer or a complaint register. All of these should be provided for. Okay. Then temporary stoppages of work, that if machinery has broken down, then work will stop. If that is not the fault of workmen, then what will be happening? This has to be provided. Provisions concerning the termination of employment and notice period, very important, that you have to provide for the entire procedure. Next, actions or inactions treated as misconduct and consequences for the fault. You cannot simply depend on the whims or fancy of the manager. You have to provide for that these A, B, C, D will be misconduct, and for some misconduct you can have fine, for other misconduct you might fire someone. So all of that has to be provided for. Then grievance redressal mechanism in case of unjust or unfair treatment by the employer. Then attendance marking system for the workers. Then employment termination and notice provided for both employer and the workers, that if the worker has to leave, then they also have to provide a notice. So that is also something that will get a standing recognition. Then the procedure for availing leave and encashment accumulation. Who do you have to file application to? How many days in advance you have to inform? All of this. Then workmen records information, that where are they coming from, how old are they, how many years they have worked for, etc. All of these details have to be disclosed in the standing order. The standing order is passed with the consultation of both employers and workmen. Okay. Therefore, and then it grants stability. Thus, standing orders, once certified, cannot be modified within 6 months of passing, except if the workman and employer both agree to the change. After 6 months, the employer or recognized trade union can apply to certifying officer to get the standing order certified. So either of them can promote an amendment after 6 months, but before 6 months there needs to be a consultation, a consensus. Otherwise, the labor commissioner can decide what is fair. Now we come to the third and last statute for the day, the Child Labor Prohibition and Regulation Act of 2016. The Government of India had promulgated the legislation of the Child Labor Prohibition Regulation Act in 1986 for the first time to regulate provisions relating to child labor practices in India. The government made substantial changes later on in the provisions of the Act in the year 2016, and thereon a complete prohibition has been imposed on employment of children who are below 14 years of age. Remember, Article 24 says children cannot be employed in hazardous activities, mines. Okay, but the 2016 Act imposed complete ban. There are some exceptions that we will discuss, but otherwise it is a complete ban. It is not limited to hazardous occupations anymore. Besides that, many provisions have also been made under the Act for employment of children who are above the age of 14. That it is understood that children have to work sometimes because of poverty. So at least after the age of 14, in what conditions can they work, that has been provided in the most comprehensive manner in the 2016 Act. So we will be discussing all of these provisions now. A child, according to the Child Labor Prohibition Act, is under 14 years of age, any person. Remember, only the Factories Act has a 15 years age limit. All others have a 14 years limit. Similarly, adolescent is above 14 years but under 18 years of age. Now there is a prohibition on child labor under section 3 of the Act. This is section 1 is basically the entire applicability over territory, that it applies to the entirety of India. Section 2 is definitions. Section 3 says that no child shall be employed or permitted to work in any establishment, occupation or process, which means child labor should not be employed or permitted to work anywhere. Under the Act, there will be a technical advisory committee to constitute. A technical advisory committee shall be constituted to advise for inclusion of further occupations and processes. Okay. So there will be constant monitoring of the situation in child labor. This act came very soon after Kailash Satyarthi ji, the founder of the Bachpan Bachao Andolan. Mr. Kailash Satyarthi won the Nobel Peace Prize in 2014 for his efforts to end child labor. So after this, in 2016, the Indian government also passed the Child Labor Prohibition Act, which prohibited all child labor in any occupation. There are only a few exceptions. We will just discuss them briefly, but this was the context in which the act was passed. Now, under the act, there are certain exceptions where children are allowed to work. A child, in the new amended 2016 amendment, a child is allowed to work at certain places. Firstly, if the child helps his family or family enterprise, which is other than any hazardous occupation or processes set forth in the schedule, after his school hours or during vacations. So, school time cannot be affected, only after school hours. Second is, if the child works as an artist in an audiovisual entertainment industry, including ad films, television, movies, or such other entertainment or sports activities, except the circus, subject to such conditions and safety measures that can be prescribed, they are allowed to work. Circus is a very big exception because the Bachpan Bachao Andolan itself had a major fight with the circus industries because they were largely related to sexual abuse of very poor children under very poor living conditions. The circuses would operate. So that is why the circus is a statutory exception. For other entertainment, such as in Bollywood, you have child actors, or in ad films sometimes, or for sports purposes, you have children. All of that is allowed, but that is also very restricted. Provided that no such work under this clause shall affect the school education of the child. Please remember, school time is the most important for the child's growth. So that has to be given primary importance, and this is what the law does. Please note, no adolescent shall be employed or permitted to work in hazardous occupations or processes. Adolescents are 14 to 18 years of age. They are not allowed for hazardous occupations or processes either. They can only work in other factories which are not hazardous. This act permits employment of adolescent labor except in hazardous processes or occupations. The number of hazardous occupations have been reduced from 83 to 3 only. This is to ensure that you can't confuse the inspector, and to reduce bribery. You will simply have 3 categories wherein adolescents cannot be employed. This also increases the scope of work for the adolescent person. No adolescent shall be employed in any of these set forth in the schedule. The schedule, as I said, has only 3: mines, inflammable substances or explosives, or hazardous process. This is basically chemicals or glass cutting processes. Okay, all of these are not allowed. The rest are provided for in the rules of the act. The rules are notified by the central government or the state government, whereas the act is made by the parliament. So rules is by government and act is by parliament. we discussed earlier that there will be a child labor technical advisory committee under the act. The technical advisory shall advise the central government for the purpose of addition of occupations and processes to the schedule, that if they feel any particular occupation is oppressive for adolescents, that they can't work in any circumstance, then that shall be added. The committee shall consist of a chairman and such other members not exceeding 10, so maximum 10 people, as may be appointed by the central government, because this is a central technical advisory committee. The committee shall meet as often as it may consider necessary and shall have power to regulate its own procedure. Lastly, the salaries, terms, benefits of the committee may be decided by the central government from time to time. That for how many years they have to be appointed, what perks and what salaries will they get, all of this will be decided by the central government depending upon the circumstances of the time. There is a restriction on the hours and period of work for adolescents. Children are specifically prohibited from work altogether, and for wherever they are allowed, there are rules under the act that can be prescribed. So, for adolescents, no adolescent shall be required or permitted to work in any establishment in excess of such number of hours as may be prescribed, or class of establishments. So, this will be prescribed by the rules. The period of work on each day shall be so fixed that no period shall exceed 3 hours, and that no adolescent shall work for more than 3 hours before he has had an interval or rest for at least 1 hour. So, if you want 6 hours of work, you have to give 3 hours, then 1 hour rest, then 3 hours. Okay. The period of work of adolescent shall be so arranged that inclusive of his interval for rest, it shall not spread over more than 6 hours, including the time spent waiting for work on any day. So, you can only have interval of 1 hour, so you can have 3 hours, 1 hour and 2 hours of work, a total of 6 hours at most. And let's say that for 1 hour they did nothing, they just waited for you to give them work, then you can work for 2 hours, or you can work even for 3 hours, then 1 hour of rest, and then 1 hour of extra work, but not more. A total of 6 hours on the employment table you can have. Under the Factories Act, if you combine these two, then 4.5 hours is for people who are 14 to 15 years old, and for 15 plus years this is 6 hours. Okay. No adolescent shall be permitted or required to work between 7 p.m. and 8 a.m. So at night they should be resting. You can't make them work on night shifts. No adolescent shall be required or permitted to work overtime. No adolescent shall be required or permitted to work on any day on which he has already been working in another establishment. Basically, the restriction on double employment is also for adolescents, and 1 weekly holiday shall be granted minimum. Okay. There are other steps which have been taken, such as the maintenance of register for adolescent employment. Penalties have been prescribed for offenders 3 months, 6 months, and for multiple years in cases of child labor engagement willfully. There is also multiple fines fines have been prescribed that will be used through the constitution of a child and adolescent labor rehabilitation fund. So the fines collected from the offenders will be used for rehabilitation of the children and adolescents who have been exploited by industrialists for labor, so that at some point they can become better human beings and better functioning adults. These were the provisions for working conditions within a factory that we have discussed so far. Let us look at some previous year questions. First, who is an adolescent as per the Factories Act 1948? A. Who has completed 15 years of age but less than 18 years. B. Who is less than 18 years of age. C. Who has completed 14 years of age but less than 18 years. D. Who has completed 16 years of age but less than 18 years. Please remember, for all other acts it is 14 years and 18 years, but for Factories Act it is 15 years to 18 years. Okay. So the answer is A. Next question. What is the maximum number of hours in a week that an adult worker is allowed to work? The answer is D, 48 hours. Including overtime, they can work for 60 hours, but that is not considered under the normal working hours. Okay. The maximum is 48 hours. The answer is D, 48 hours. Next, questions relating to application or interpretation of a standing order certified under the Industrial Employment Standing Orders Act may be referred to: A. Industrial Tribunal, B. Labour Commissioner, C. Labour Court, or D. Industrial Employment Court. The answer is B, Labour Commissioner. Labour Commissioner is the certifying officer for all standing orders. Industrial Tribunal and Labour Courts are used for industrial disputes, not for Standing Orders Act. Okay. Therefore, the answer is B. Thank you. Hello everyone. Welcome to the 7th class for Industrial Relations and Labour Law for EPFO. In this class, we shall discuss women welfare provisions as well as the labour codes, the new labour codes which have been passed by the Government of India in 2020. Okay. So, let us begin. First, let us discuss some issues that women face at workplace. The first major issue is that there is a wage gap. This is also called the gender pay gap, that women are paid less for the same work. We had discussed that Article 39 provides a directive principle for state policy of equal pay for equal work, and with regard to this there is an Equal Remuneration Act 1976 which was passed. However, the gender gap index still says that India has a very high gender gap that will take about 100 years to resolve at present. So the gender gap, especially the wage gap, continues to persist in India. The second major issue that women face inside the workplace is low female labor force participation. India's female labor force participation has gone down to 20%, that out of 100 women, which could have participated in the labor force, only 20 are working. So this is one major issue, that is reducing the productivity of the economy as a whole. This also means that there are less role models for women at workplace, because they cannot see so many people succeeding as women, so that can also be a very big discouragement. So this low female labor force participation is a major issue. Even amongst the participating females, about 70 to 80% are in agriculture. So the female labor force in the manufacturing sector is even lower, also in the hospitality and other services sector. Third issue is the glass ceiling. Glass ceiling is a term which means that there is a ceiling in the hierarchy of the company above which women cannot rise. So for example, let's say there is a woman and a man at the same post in a company. Both of them will face certain promotions at the same rate or similar rates, but afterwards at the director level or CEO level, the industry is dominated mostly by men, that women are not promoted so much in the highest level of employment. So this is called glass ceiling. This is also because of the social stigma that women cannot be good managers. Then the next issue is sexual harassment, that sometimes men, especially senior men, try to take advantage of female employees. They try to gain sexual favors, or they try inappropriate language with women. All of these are major issues that can discourage women once again from coming to work every day. The last is patriarchal expectations, that given that society is largely patriarchal, there is an expectation that women should be a caregiver and a homemaker. Because of this, we see educated women have lesser female labor force participation because they prefer to be mothers, because of the family expectations that who will take care of the children if not the woman. In agriculture and the poorer classes of citizens, the women have to work. They have no option. But in the richer households, women choose to not work because there is an expectation that they should be mothers. So these are some of the issues that women face at workplace. Now let us discuss the sexual harassment law. The Sexual Harassment of Women at Workplace Prevention, Prohibition and Regulation Act 2013 has been passed to regulate sexual harassment. It is also called the POSH Act. POSH stands for Prevention of Sexual Harassment. So this is called the POSH Act. This was passed alongside the Criminal Law Amendment 2013. If you might recall, there was a major case, the Nirbhaya case, which shook the conscience of the country in 2012 December. So therefore, after that, in 2013, multiple laws were brought in place to ensure that women are not harassed sexually, as well as the penalties for rape and other women related offences were also increased. The law on sexual harassment is based on the Supreme Court's guideline in the Vishakha case. The Vishakha versus State of Rajasthan was a judgment of the Supreme Court in 1997, wherein the Supreme Court laid down guidelines for prevention of sexual harassment at workplace. Okay. So these are some laws and these are some basics for the POSH Act. Now let us come to the definition of sexual harassment according to the POSH Act. So under the Act, sexual harassment is any unwelcome sexual behavior, whether directly expressed or implied, and includes cases of physical contact and advances, or a sexual favor demanded or requested, or making remarks with sexual overtones, or showing pornography or other offensive material, or acting in an unwelcome sexual manner through physical, verbal, or non-verbal means. So it's not that you have to say things or you have to touch someone, but for example, if you make weird gestures from afar, from a distance, let's say within the workplace or outside it, you point towards your private parts while looking to a woman, that will be sexual harassment, even though you are not physically in contact with the woman and you are not verbally saying anything, but that will still be sexual harassment. And other such cases, such gestures or any other behavior that you do can also be counted as sexual harassment. Okay, so this is unwelcome sexual behavior, that you call someone over to your house at late at night when they have clearly said that they don't want, or physical contact, that you touch someone on the shoulder or on their back unnecessarily, that is not required, or you demand sexual favors, physical contact, favors, or you make remarks, or you show pornography or other offensive material, then all of this will be a act of sexual harassment. Okay. This also includes, firstly, a promise of preferential treatment at work just because someone is a woman that you are interested in. If you promise preferential treatment at work, that will be sexual harassment. Secondly, a threat of adverse treatment in the workplace that is implied or explicit. So if you ask someone to come to your house late at night and if they reject, and then the next day you demote them, then that is also sexual harassment. Third, an implied or explicit threat regarding a person's employment status, present or future. The same example will work here also. Fourth, interference with work or creating intimidating or offensive or hostile environment for someone. For example, you talk about someone's personal life in the office space openly, that will also be sexual harassment. Lastly, humiliating treatment likely to affect the lady employee's health or safety, that you may make them work in some conditions, or you prescribe a dress code that is inappropriate for the workplace. All of this will be also be amounting to sexual harassment. Okay. These are some provisions of the POSH Act. These were first recommended by the Supreme Court in the Vishakha case only, and afterwards in 2013 it was codified through the POSH Act. Firstly, it is the responsibility of all employers with 10 or more workers, with women also employed is not a mentioned condition. Okay. So, as soon as you have 10 or more workers, you have to constitute an internal complaints committee under the POSH Act. It's implied that there should be women employed for you to have one, but the law requires all employers with 10 or more workers to constitute internal complaints committee under the POSH Act. For other establishments, the local committee under the supervision of the district magistrate at the district government office has to be established. Basically, for 10 or less members, for less than 10 members, you will have a local committee, and for complaints against the employer, you will have the local committee. Okay. The employer has a duty to raise awareness about sexual harassment provisions in the POSH Act and display the measures taken to prevent sexual harassment at workplace. Lastly, the POSH Act is not gender neutral, that the problem can only be raised by an aggrieved woman. It cannot be by a man or the third gender. At present, it's not a gender neutral act. Okay. The main mechanism in the POSH Act is the Internal Complaints Committee. It's now called the Internal Committee in the statute after 2019. So, the composition is that there shall be a female presiding officer who is an employee at a senior level at work. Secondly, there should be at least 2 members amongst the employees. These members shall be ideally committed to women's causes or have social work experience or legal knowledge. Thirdly, an external member is required who should be from NGOs or associations that support the cause of women or have experience in sexual harassment issues. As per Rule 4 of the POSH rules, the external member shall be an individual with expertise in workplace sexual harassment issues, such as social worker with at least 5 years of experience or somebody familiar with labor, service, civil or criminal law. Okay. So, basically, you need a lawyer on the panel or a social worker. It need not be a woman, but normally the external member is a woman. Next point, at least one half of the internal committee's total must comprise of female members. The internal committee members have a maximum term of 3 years. Lastly, an inquiry must be conducted by at least 3 members of the IC, the internal committee, including the president. So, whatever complaint is provided, at least 3 members of the internal committee, including the presiding officer, have to be involved in the investigation of the complaint. Let us also look at the local complaints committee. In 2019, this was also called the local committee. So, both terms now are being used. So, the local complaints committee or the local committee is at the district government office under the DM or the district magistrate. This applies to fewer than 10 employees, establishments with fewer than 10 employees, and when the complaint is against the employer only, because you cannot complain against the employer within the ICC of the establishment, because the employer will not be subject to any other penalty. So therefore, you can go to the local committee. The composition for the local committee is as follows. Firstly, the chairperson shall be a woman. Such a woman shall be a women's rights activist and an eminent social worker. Okay. So a social worker in the field of women rights. Second, there shall be a local woman who shall be nominated amongst women who work in blocks, talukas, tehsils, wards and municipalities within the district. So basically a government officer, a female government officer who is a local. And thirdly, NGO members. There shall be 2 NGO members, one of whom must be a woman from organization dedicated to women's issues or a person knowledgeable about sexual harassment issues. It is further recommended that at least one member has legal experience and one belonging to scheduled caste, scheduled tribes should at least be one of the members. Okay. So the exact strength of the local committee is not defined. It is only that there should be one chairperson who is a female rights social activist. Then there is a local government officer woman. Then there is an NGO member, at least one of whom is a woman experienced in sexual harassment issues. The other can be a someone with legal experience, and one person from the SC/ST categories, so that the specific pain of those people can also be understood. Okay. The internal committee shall follow the following procedure. Firstly, the internal complaints committee shall have the powers of a civil court for the purpose of summoning witnesses and examining documents under the documents on oath. Powers of a civil court are provided under the Civil Procedure Code. Okay. And this continues to be expanded because any body with the power of a civil court can call witnesses, examine witnesses and inspect documents. So all of these 3 are powers of a civil court. Secondly, the aggrieved woman can file a complaint within 3 months. This can be extended by the ICC, that if it is more than 3 months, then the ICC can give reasons as to what prevented the woman from raising the complaint in due time, and afterwards it can give a extension to the woman also. Okay. And thirdly, the ICC can attempt to resolve a complaint between the parties at the request of the aggrieved woman through conciliation by reaching an amicable settlement. So only if the woman requests will the internal committee provide conciliation. Otherwise, it will not. Okay. This is the general procedure of the internal committee and how they will proceed for inquiry. They can regulate their own procedure. The internal committee, because the size of the different enterprises will be different. Different size of enterprise, different work conditions, different documentations. So every internal committee should take its own decision as to the procedure as well as the final answer. The punishments under the Prevention of Sexual Harassment Act firstly says that the employer must punish employees found guilty of misconduct according to the organization's service rules, that it is important to frame such rules by the organization. Secondly, disciplinary actions may include a written apology, warning, reprimand, censure is criticism by the official authority, withholding of promotion, withholding of pay rise or increment, terminating from service, undergoing a counseling session, or performing community service. Lastly, it is also allowed to reduce the respondent's wages to pay compensation to the aggrieved woman. So you can cut their salary and dedicate that portion of the salary to the aggrieved woman who has been a victim of sexual harassment. Okay. The employer will face a liability in certain cases. Firstly, if they fail to constitute an ICC, then they will be liable under the law. There is also criminal liability prescribed. So this was with the intention of ensuring that employers will establish internal committees. However, small establishments don't normally do this. Don't do this. It is not easy to regulate anyway, so they don't. Then, if the employer divulges details of the ongoing case, if they fail to maintain the confidentiality of the agreement, of the entire proceedings, then also they will be liable. And thirdly, if they fail to propagate knowledge about the procedures, if they haven't displayed on the notice board what the sexual harassment policy of the entire place is, or that they haven't tried to raise awareness even once, then also they can be made knowledgeable. This can lead to a fine of up to 50,000 rupees for failures to perform their duties under the Act, and this is only in the first instance. In later times, criminal liability can also be imposed upon the employer. They can be imprisoned for some time and penalized for not taking action. That was the law on sexual harassment that we discussed. Now let us discuss the labor laws that have been passed. So we'll discuss three of them: the Code on Wages, the Industrial Relations Code, and the Occupational Safety, Health and Working Conditions Code 2020. The Social Security Code provisions we'll discuss in the class on Social Security. Okay. These three will be discussed in the present class. We have seen that in 2020, the government replaced 29 central laws with 4 labor codes. These 4 labor codes have still not been implemented, but they have been enacted. So it is likely that a question can come either in the coming years very soon, because the provisions have now been enacted, have been passed by the Parliament. So we'll be discussing the provisions now. Okay. First is the Code on Wages. The Code on Wages merges 4 laws into one: the Minimum Wages Act 1948, the Payment of Wages Act 1936, the Equal Remuneration Act 1976 and the Payment of Bonus Act 1965. All these four have been merged into one. Okay. Remember, we were discussing in the class on wages that the Minimum Wages Act prescribes the consequences of not paying wages as well as defined the wages for different groups. The Payment of Wages Act provides for the date of payment of wages. The Equal Remuneration Act provides for rate of payment of wages for different genders. And the Payment of Bonus Act provides for sharing of profits of business with the employees. Please remember, bonus under the Payment of Bonus Act is mandatory even if there is a loss. Alright. Let's discuss the provisions of the Code on Wages. First, we come to the definition of wages. Here, wages means all remuneration, whether by way of salaries, allowances or otherwise, if the terms of employment were fulfilled, be payable to a person employed in respect of his employment. Therefore, there is no specific relation of the employee. Please note that the word employee is not mentioned, only employment is mentioned. So this means that you don't have to prove anymore that you are an employee of the company in question, only that you worked for them at some time and you were in their employment. This is a technical legal question and at present it has not been interpreted by the courts, but this is one of the major problems of dispute, that whether someone is an employee or not in labor courts. So this is a issue that might arise in the future. Second definition is employer. Here, employer means a person who employs, whether directly or through any person, or on his behalf or on behalf of any person, one or more employees in his establishment. Okay. So basically, both the contractor and the principal employer can be held liable. Okay, because the employer is person who employs, whether directly or through any person. So therefore the principal employer, and or on his behalf or on behalf of any person. So therefore the contractor is also involved. The scope of wages has been curtailed under the Code on Wages. It includes basic pay, dearness allowance as well as retaining allowance, but it no longer includes bonus, PF contribution, conveyance allowance, house rent allowance, overtime allowance, commissions, gratuity or retrenchment compensation. Okay. Now, this new concept of wage floor has been introduced. The concept of wage floor is to be fixed on the basis of minimum living standard of a worker by the central government in consultation with the state governments and the Central Advisory Board on Wages. Okay, we had discussed that there is a Central Advisory Board under Section 8 of the Minimum Wages Act. The wage floor can be a single floor for the entire country or different floor wages for different geographical areas. Floor is basically something that you cannot go below. So it is possible that the central government may fix one wage floor and then every state government might fix it is possible that the central government might fix one wage floor and then different states might fix different wage floors. Okay. The minimum rate of wages to be fixed by the central government and state government should either be equal to or above the wage floor and can't be reduced to the level of the floor if wages are already higher. So therefore, if the government has fixed a wage floor, but the minimum wage at present is much above, then the government cannot go down to the wage floor. You have to be either above or at. At or above are the only options for the wage floor with any government. Other key reforms in the Minimum Wages Act and the Code on Wages are, firstly, the Code on Wages outlines a uniform statutory criteria for initially setting and subsequent revision of the minimum wage rates, ordinarily in every 5 years, because they allow for a wage floor. So governments can always set a higher wage rate, but the new wage rate that they set will continue to become the next wage floor. So basically, you can always set new criteria and revise them upwards. This ensures wage fixation on time as per fixed norms, devoid of any arbitrariness as witnessed presently, because at present minimum wages can be revised in any direction. This has to be ordinarily every 5 years. Okay. Secondly, the Code on Wages provides for timely adjustment of minimum wages with respect to inflation every 6 months. So on 1st April and on 1st October, the inflation adjustment has to be done to protect the real wages of the employees. Real wages are at constant prices adjusting for inflation, and nominal wages are at current prices. The difference between this is a question of economics, that let's say everything, a basket of apples plus oranges etc. cost 10 rupees in 2011 and my salary was 100 rupees. The same basket now costs 20 rupees in 2023 and my salary is 150 rupees. I am now poorer in reality, although I am earning more. 150 is greater than rupees 100, but my expenses have risen at a faster rate than my income, and therefore I am actually poorer. So therefore, to protect real wages of the employees, the inflation adjustment happens every 6 months. Okay, remember, minimum wage setting has to be done at ordinarily in every 5 years, and inflation adjustment has to be done every 6 months. Third, there is a simplified and rationalized existing complex minimum wage structure. So the Code on Wages has simplified and rationalized the existing complex minimum wage structure to reduce the number of minimum wage rates from the existing 1915 rates to a minimum of 3 and maximum of 12 per state. Okay, because at present every state sets its own wages for any number of classification. So this is a very high number of 1900 plus rates. Now there will be 3 to 12 rates in every state. So this will improve the ease of doing business across states because compliance is easier. Compliance is easier. Lastly, through increased awareness of fewer minimum wage rates, there is expected to improve enforcement, compliance and effective application of the minimum wage system across the country. The authorities will also be able to catch someone more easily because they are violating very specific set of laws. Compliance is easier, we just discussed, and the application of the minimum wage system will also be easier because the employees will also know. Okay, so these are some key reforms. There are other key reforms in the Code on Wages. Fifth, that the definition of employer has been extended by classifying a contractor as an employer also. Okay, because anyone who employs someone on behalf of another is also an employer for the purpose of the Code on Wages. Next, that the Code on Wages provides clear and uniform definition of wages and remuneration. So this allows for a single standard to prevail as to what constitutes wages. Lastly, second last, that it restricts in-kind payments to a maximum of 15% of the total wages. So you cannot have too much of house accommodation or sanitary benefits, etc. beyond 15%. Okay, there is a maximum ceiling. After that you have to pay in cash. Lastly, the overtime compensation is twice the normal wage extended to all employees, not just for workers. So earlier, the managerial or administrative staff were not included. However, now they are. And another issue is that the written consent must be obtained before subjecting employees to overtime. You have to ask permission from the employee for overtime. Otherwise, you cannot force them, cannot force someone into overtime work. Some other reforms that you might just look at, these are not as major as the previous ones, but this has universalized timely payment of wages to all employees in all establishment irrespective of wage ceiling. This is a significant development in terms of wage protection of employees, and this enables them to receive wages on time. This act promotes digitization in wage payments through bank account and electronic mode. There is a recommended way of transfer. Every employer shall issue wage slips to the employees. In case of removal or dismissal or retrenchment or resignation, or someone became unemployed due to closure, wages shall be paid within 2 working days. The Code on Wages puts responsibility of payment of all dues and burden of proof on the employer in case of claims relating to non-payment of dues. Therefore, they have to maintain wage slips or payment records. There is a limitation period for filing claim before the authority, which has been increased to 3 years as against 6 months to 2 years earlier. So for different wages of different classes, if you went after 6 months, you could not claim. Now that has been increased to 3 years. So you have larger time. This also encourages digital payment because the record will always be there. There is also a fast track claim adjudication process for the purpose of this code. This ensures that non-payment of dues does not hinder the living standard of workers. The code on wages also limits the number of deductions possible. There shall be no deductions from the wages except those as authorized under the code. These are the permissible deductions. An employee's wages may be deducted on the grounds of fines, absence from duty, accommodation given by the employer, recovery of advances, loans given to the employee, and income tax or other statutory levy, among others. The total amount of deduction shall not exceed 50% of the employee's total wage in any wage period. So you cannot fine excessively. If there is too much of a damage that someone has done, proceed against them in court for recovery proceedings. You can't cut their wages as a fine. If deductions exceed 50%, the excess may be recovered by the employee. This again will come through the claims process. Now we come to the Occupational Safety, Health and Working Conditions Code of 2019. This code seeks to regulate the health and safety conditions of workers in establishments with 10 or more workers and in all mines and docks. Although in any mine or dock there will always be more than 10 workers. This subsumes and replaces 13 labor laws relating to safety, health, working conditions. Major acts such as Factories Act, Mines Act, Dock Workers Act, many others, we will discuss them, have been replaced and merged into one single code, the Occupational Safety, Health and Working Conditions Code. Okay. The establishments covered by the code are required to register with registering officers appointed by central or state governments. The welfare facilities, working conditions and work hours for different types of establishments will be prescribed by the central or state governments through rules. Please remember, this is going to be a major part of the new occupational law, that most of the law shall be prescribed through rules only. The law itself does not provide for any major standard. It only provides for guidelines which shall be prescribed in detail by the central and state governments. The code sets up Occupational Safety Board at national and state level to advise central state governments on standards, rules and regulations to be framed. The code creates special provisions for certain classes of establishments such as factories, mines, dock, construction workers. These include provisions on licenses, safety regulations and duties of employers. Most of these will also be prescribed through the rules. Okay. So these are the 13 laws which have been replaced. The Factories Act 1948, we had discussed this in detail. Then the Mines Act of 1952, the Dock Workers Safety, Health and Welfare Act of 1986, Building and Other Construction Workers Regulation of Employment and Conditions of Service Act 1996, Plantation Labor Act 1951, Contract Labor Regulation and Abolition Act 1970, Interstate Migrant Workmen Regulation of Employment and Conditions of Service Act 1979, Working Journalist and Other Newspaper Employees Condition of Service and Miscellaneous Provision Act 1955, Working Journalist Fixation of Rates of Wages Act 1958, Motor Transport Workers Act 1961, Sales Promotion Employees Condition of Service Act 1976, BD and Cigar Workers Condition of Employment Act 1966, Cine Workers and Cinema Theatre Workers Act 1981. All of these 13 laws have been replaced by the Single Occupational Safety and Working Conditions Code. Okay. The applicability of this code is for establishments employing at least 10 workers and to all mines and docks. This code does not apply to apprentices. The government is coming up with a separate apprentice policy, and at present it only applies to workers. Further, apprentices also normally work with a master. They are not employed in workspaces normally. However, in this case, it will not apply to apprentices. Further, certain provisions of the code such as health working conditions apply to all employees. Employees include workers and all other persons employed in a managerial, administrative or supervisory role with a monthly wage of 15,000 rupees. This is maximum of 15,000 rupees. The duties of employers under the Act are as follows. Firstly, providing a workplace that is free from hazards that may cause injury or disease. Second, providing free annual health examinations to employees in notified establishments. Thirdly, issuing appointment letters to employees. Fourthly, informing relevant authorities in case an accident at workplace leads to death or serious bodily injury of an employee. Additional duties are prescribed for employers in factories, mines, docks, plantations, building and construction work, including provision of risk-free environment and instructing employees on safety protocols. However, just like the other provisions, these are also going to be prescribed in details through the rules, and the rest is only a guiding provision. In delegated legislation, we have guiding provisions, and this is only a guiding provision. Okay. Now we come to the Industrial Relations Code. The Industrial Relations Code replaces basically 3 laws. First is the Trade Unions Act 1926. Second is the Industrial Employment Standing Orders Act 1946. And third is the Industrial Disputes Act 1947. All of these are very big laws. We had discussed all of them in the previous classes, and the Industrial Relations Code seeks to replace them and merge them into one single law. Okay. So let us see. First, there is a contracting scope of the word industry by defining the same so as to exclude institutions owned or managed by organizations wholly for or substantially engaged in charitable, social or philanthropic services. or sovereign functions or domestic services. So basically, if there are charitable organizations, they will be not included in some cases. There will be cases where they are included, but there are exceptions. Secondly, for sovereign functions such as defense research, etc., this will not be provided. And lastly, the domestic services are not included. So, housemaids, etc., are excluded. This is just to clarify what industry meant, because over time there have been multiple litigation up to the Supreme Court level also for definition of who is a worker, who is an employee. This court seeks to do away with all those controversies. So this was the first part, major change in definition. Second major change is the definition of worker has been enhanced from 10,000 to 15,000 per month. Okay. Beyond this, one may not qualify as a worker wherever required, but this is also a major change. There are certain new features which have been included in the code on in the industrial relations code. First is the idea of fixed term employment. Fixed term employment is something outside of both permanent employment and contract labor. It is at the juncture of this, that let's say this is permanent employment and contract labor. So fixed term employment is somewhere between. It means that there is engagement of worker on the basis of written contract for employment for a fixed period. That it is not that you are an employee until you are fired. You are only for a fixed period as per the contract itself. So let's say you hire a consultant for 2 years. That is you are a coaching institute and you hire a teacher or a specialist, etc. All of these can be for a fixed term. The fixed term employee will get all statutory benefits like social security, wages, etc. at par with regular employees who are doing the same work or similar work. Okay. So therefore, this is what fixed term employment is, that you are earlier this was not in any provision. So people would go to court claiming all benefits the same way as an employee. Now this has been properly given a legal form. The next is a negotiating council, a negotiating union and a negotiating council. So normally there are multiple trade unions in many industrial establishments. The Industrial Relations Code says that any trade union with at least 51% of workers will be considered sole negotiating council. They will be the only council which will collectively bargain. The Industrial Disputes Act did not have a very clear provision for recognition as to which trade union is recognized. Now, the negotiating union has been clearly defined that at least 51% of the workers, if they exist in one trade union, then that will be the sole negotiating union. In case no union has at least 51% as members, a negotiating council shall be formed consisting of all unions that have at least 20% of the workers as members. Okay. So this negotiating council will have representatives of, let's say there are 3 unions, both with 33%, 40% and 27% workers. then all of these will have their representatives in the negotiating council, and then this council will collectively bargain. Alright. There are certain restrictions on employers under the code, the Industrial Relations Code, from interfering, restraining, coercing workers in exercise of their right to organize, form, join or assist trade unions, or to engage in concerted activities for purposes of collective bargaining or mutual aid or protection. So the employer cannot interfere, the employer cannot dominate, interfere or contribute, support financial or otherwise to the trade union. The employer cannot establish an employer sponsored trade union. So you cannot say that there is one trade union which is supported by the employer itself. That is the right of the workers. Remember, Article 19(1)(c) provides it as a right of the workers to form unions. Okay. And lastly, to encourage or discourage membership in any union by discriminating against any worker. This is no longer allowed. That is a major restriction on employers, that you cannot stop union activity. You can deal with the unions themselves, but you cannot stop people from forming a union. There are further restrictions on employers, that you cannot discharge or dismiss workers by way of victimization through not in good faith and in colorable exercise. Colorable exercise is when you are authorized but you are misusing your powers. Let's say your employee does not talk to you in a respectable manner, and you say that amounts to insubordination and fire them. That is not, that is only victimization and a colorable exercise. So that is not allowed. Okay. Secondly, by falsely implicating a worker in a criminal case on false evidence or concocted evidence, or for patently false reasons, on untrue or trumped up allegations of absence without leave, misconduct or minor technical issues. And thirdly, in utter disregard of principles of natural justice in conduct of domestic inquiry with undue haste or through disproportionate punishment. So you can only treat people in a just and fair manner. There are further restrictions, that the employer cannot abolish the work of a regular nature and bring contractors to break a strike. You cannot employ workers as badli workers or casual workers and continue them for years with the object of depriving them of privileges of permanent workers. So you cannot misuse legal provisions. You cannot insist upon individual workers who are on a strike to sign a good conduct bond as a precondition for allowing them to resume work, or to discriminate or discharge workers for filing charges in a proceeding in an industrial dispute. So basically, you cannot victimize employees. There are also restrictions on workers and trade unions. They cannot instigate any strike that is illegal. They cannot coerce workers to form a trade union or from refraining from joining a trade union. It is the fundamental right of workers to join as they please. For a recognized union, they cannot refuse to bargain collectively. Provisions such as go slow, squatting or gherao, we had discussed in the trade unions class, are no longer permitted. You cannot stage demonstrations at the residence of the employers or managerial staff, and you cannot cause willful damage to the employer's property connected with industry. There is also a requirement of notice in case of change in the following circumstances. The employer has to provide reasonable notice. You cannot change without notifying the workers. Firstly, on wages, including the period and the mode of payment, this has to be notified. The contribution paid or payable by the employer to the provident fund or pension fund. The hours of work and rest intervals. Leave with wages and holidays, which gazetted holidays which will be followed, etc. All of this has to be notified. And the starting, alteration and discontinuation of shift. So it is within the act itself that you have to notify in case a change happens, so that once again employees are not victimized. So these were the changes that have been brought forward by the three major codes: the Industrial Relations Code, the Code on Occupational Safety and Health and Working Conditions, and the Code on Wages. We shall discuss the Code on Social Security when we begin Social Security. Alright, thank you.